It's 10 o'clock, and I'm going to call this hearing to order. This is our fourth in a series of hearings on our American Energy Initiative. And that initiative is designed to explore obstacles to helping America become independent on its energy needs, both for transportation and also relating to the production of electricity. Our goal is to try to find and locate and identify obstacles to that independence and then try to take actions to deal with it. In addition to identifying obstacles, we're also trying to be proactive in ways to make it easier for production of domestic resources. Today's hearing focuses on one part of this initiative, and that is the Jobs and Energy Permitting Act of 2011, which has been released in the form of a discussion draft by the gentleman from Colorado, Mr. Gardner. I would just say that this came about because we identified a problem up on the shelf off the coast of Alaska, in which a company trying to do exploration has been involved in a process that has taken over 5 years to obtain a permit. And that was precisely the purpose of our hearings on American Energy Initiative, is to, as I said, locate those obstacles, identify those obstacles, and then try to deal with it. So at this time, I'd like to yield to the gentleman from Colorado for a more thorough explanation of his discussion draft.
Thank you, Mr. Chairman. Thank you for the hearing today. Look forward to working with you and other members of the committee. And thank you to the witnesses that will be testifying today. I come from an energy-producing state, and I have had the privilege of collaborating with many colleagues from other such states in a project that we're calling the American Energy Initiative. Of course, there are significant regional differences. The oil and gas industry in the Rockies faces different technical, economic, and legal challenges than oil and gas in the Gulf of Mexico or elsewhere. And coal production in Colorado and other western states has both similarities and differences with our Appalachian counterparts. But whichever energy-producing state we come from, one thing that we all have in common is that the federal government is holding us back from meeting our potential to produce more domestic energy. Changing that is going to be a big part of the American Energy Initiative. This is our fourth multi-day hearing on the American Energy Initiative, and today we are going to focus on offshore oil and gas production, and especially streamlining the process of offshore permitting. These impediments have already delayed activities in the Beaufort Sea off of Alaska's North Slope, where exploration has yet to even begin on leases that were signed over 5 years ago. The Jobs and Energy Permitting Act of 2011 discussion draft seeks to address current problems in EPA's offshore permitting requirements. Offshore Alaska holds tremendous potential, but not if we allow the status quo to continue. Production in the Arctic OCS could provide 1 million barrels of oil a day, comparable to what we currently get from Saudi Arabia. But unlike Saudi Arabia, this domestic production is blocked by a convoluted permitting system in place that is difficult, if not impossible, to navigate. The fact that the owner of the leases had already secured something like 35 permits but could not start drilling because it could not get the 36th would be funny if not for the adverse consequences in lost domestic energy and lost jobs. Keep in mind, we are not talking about an area the federal government has placed off limits to energy leasing, of which there are far too many. We are talking about an area that was already leased, but for which the lease is essentially being nullified with red tape. That needs to change. The current anti-domestic energy philosophy is not what the American people want. No matter how many times President Obama insists that America doesn't have enough domestic oil to make any difference, the public isn't buying it. They want our oil supplies unlocked and understand full well the benefits of doing so. They see the impact that production has in their communities and the jobs it brings. This bill alone has the potential to create 40,000 to 50,000 jobs annually and $75 billion in payroll. And we're not just talking about jobs and income in Alaska. Increased oil production in Alaska will result in jobs across the United States. One thing I can attest to is that a majority of Coloradans support increased energy production in the state. Yes, we expect strong environmental safeguards, But we don't want those safeguards to be exploited by activists into an excuse to shut the energy industry down. Coloradans are proud to live in a state that produces energy for the rest of the nation and recognizes the benefits in terms of high-paying jobs as well as state and local revenues. And as we will soon hear, that sentiment is true of Native Alaskans as it is of Native Coloradans. In fact, there are very few elected officials from Alaska who support the existing constraints on energy production there. We have a great panel, including some who came from very far away to be here and who booked their flights in the midst of a potential government shutdown. So we really, truly appreciate your time to be here today. And I look forward to learning more about Alaska's energy situation and what we in Congress can do to improve it. Thank you very much for the opportunity to hear this bill today and for your work and testimony today.
Thank you, Mr. Gardner. At this time, Mr. Rush, you're recognized for 5 minutes.
I want to thank you, Mr. Chairman, and I want to thank all of the guests who are going to be with us today. Mr. Chairman, today we hear testimony regarding the discussion draft of the so-called Jobs and Energy Permitting Act of 2011, which will amend Section 328 of the Clean Air Act that addresses air pollution from outer continental shelf drilling activities. While I have some reservations about the bill as written, my biggest concern with today's hearing is that we will not have the opportunity to hear from representatives from the Environmental Protection Agency. As I'm told, they were not given sufficient advance notice in order to appear before us today. And I find it very troubling that we're here to discuss amending sections of the Clean Air Act without the benefit of having EPA's expertise to help guide and inform our decisions. As you know, Mr. Chairman, Ranking Member Waxman and I wrote you a letter, and Chairman Upton on Friday asking you to postpone this hearing until we could have the appropriate representatives from EPA testify before us. And I'm surely disappointed that this reasonable request could not be met, since this bill would make significant changes to the Clean Air Act rules that EPA is in charge of implementing. I only hope that as this discussion draft moves through the legislative process, that we will get a chance to hear from EPA directly at any future hearing scheduled on this bill in order to help inform the final product. As far as the discussion draft itself is concerned, one of my main concerns deals with expediting the permitting process, which may limit the opportunities for review and for public input. While I'm not necessarily against streamlining the permitting process in general, I want to make sure that we are giving local communities adequate time to comment on proposed permits before they are enacted. Another concern deals with shifting the judicial review away from the Environmental Appeals Board, which has almost 20 years of experience in the highly technical area of prevention of significant deterioration, or PSD permits, and moving the process to the D.C. Circuit Court of Appeals, which lacks any of this technical expertise, requiring local stakeholders to travel all the way to Washington, D.C. in order to raise concerns about local air quality impacts could prove to be overly costly and also burdensome, if not outright impossible for less well-to-do communities. Finally, I look forward to hearing more discussion regarding the application of emissions control requirements under the Prevention of Significant Deterioration PSD program of the Clean Air Act. Under the proposed legislation, support vessels such as icebreakers and oil spill response vessels, which may contribute a majority of the air pollution associated with drilling activities, would not be subject to best available control technology emission reduction requirements or other requirements adopted under the PSD program. I would like a better understanding of how this would impact air quality for local communities. So I look forward to today's hearing. I look forward to hearing all of our witnesses today in order to get a better understanding of how this proposed legislation would impact local stakeholders as well as how it would benefit oil and gas companies conducting the drilling in the outer continental shelf. Mr. Chairman, I yield the balance of my time to the ranking member if he wants my time and his time also. If anybody else wants some time. Okay, just wait. Okay, I yield back the balance of my time.
Mr. Rush, I would just make one comment. We did invite EPA representatives to attend today's hearing and Friday's hearing. They have refused to come. I believe they have a lot of qualified people over there, and maybe just because Gina McCarthy was unable to come, I know they have enough qualified people to come and attend these hearings. We, as you know, have a full schedule of hearings. We intend to move a lot of legislation, and we're not going to allow EPA to dictate our schedule. And at this time, I recognize the gentleman from...
Mr. Chairman, if I can respond,
yeah.
I think that it's reasonable that the EPA should be given adequate notice. Now, I mean, I just don't think that we can continue just to barrel through this without EPA giving adequate notice, and I think that's reasonable.
I think I think we did give them adequate notice, and hopefully they'll come at our next hearing. At this time, I recognize the gentleman from Texas for 5 minutes.
I thank the gentleman. You know, I don't think it takes a rocket scientist to understand we're reviewing a lot of things that the EPA is involved in. With all due respect to my good friend, Mr. Rush, it's a 3-minute cab ride from the EPA building. It's a 10-second phone call. And if they don't know that they're going to be called to testify before this subcommittee and this full committee numerous times in the next 2 years, they need to take an IQ test, because they're going to be called. And if Mr. Waxman and Mr. Rush needs to let them know that, if they don't understand what Mr. Whitfield and Mr. Upton are saying, maybe we're not saying it in the right way or the right tone, but it's no surprise that we're going to be asking the EPA to come and justify or at least give their comments on some of the things that we're doing. Well, I'm very glad to see my good friend, Mr. Young. We have a tremendous expert here in the Congress and former chairman, 2 committees, and we know he's an expert on Alaska, and after he does whatever he does, he'll be back. This is a
he'd better hurry up, because we got a lot of business to take care of.
This hearing, Mr. Chairman, is going to be a revelation to the country, I believe, when they find out what the EPA has not done up in Alaska. We have tremendous oil and gas potential in the outer continental shelf. And under the Clean Air Act, the EPA, unlike the Gulf of Mexico, has the right to give some of these permits. When you hear the representatives from some of the industry testify later in today, I think panel members are going to be stunned that the reason these permits haven't been given is because they can't decide whether it's a stationary source or a mobile source, because it's a drilling ship, not a drilling platform. They can't decide where to measure air quality, whether they measure it at the side of the ship, on shore, or someplace in between. It's the most bureaucratic gobbledygook I've ever encountered. Permits, you know, there's absolutely no question that the EPA has the authority, but just because you have the authority doesn't give you the opportunity just to sit on your hands and think up one bureaucratic excuse after another to not make a decision. And that's, I believe, what we're going to find today. We need to have a responsible drilling program. The President himself, with respect to this particular area of our country, stated in his blueprint for a secure energy future on March the 30th that the administration remains committed to facilitating development in this region, which will require consideration across the federal government. He went on to state that a cross-agency team would be created to coordinate and facilitate efficient offshore permitting. So I'm going to yield the balance of my time to Mr. Shimkus, but this hearing is one that we really need to pay attention to because of the huge potential we have for domestic oil and gas production in the OCS off the coast of Alaska. And with that, I yield the balance of my time to Mr. Shimkus.
Thank you, Mr. Barton. America is one of the few countries that sees its natural resources as a hindrance, not as a national advantage. We've said this numerous times, and as gas prices go up, we have to make sure we fully use our natural resources. I know about Alaska, and I know about jobs. My late father-in-law worked on the Alaskan pipeline. He was a microwave communication engineer. He flew the pipeline. He was one of many people who came up from the lower 48 to get good-paying jobs and raised a family of 3. So that's fossil fuel energy development is job creation in an economy that needs jobs. And I'll end on this. There are over 17,000 employees in the Environmental Protection Agency. 17,000. Surely one of them could have come to the hearing, I would imagine. Maybe one could have come to the hearing, and all the other hearings we're going to be holding in the future. So
Gentlemen,
I would be happy to.
I understand that the janitor is available. And he said,
Well, for some of us, maybe the janitor would give better testimony than some of the career bureaucrats they have in the EPA. Yield back.
The gentleman from California, Mr. Waxman, is recognized for 5 minutes.
Mr. Chairman, today's hearing examines legislation to amend the Clean Air Act provisions that protect air quality when offshore oil and gas are developed. I hope we can reach agreement on this legislation, but I cannot support it in its current form. This legislation is being considered at the behest of a single company in response to 2 permit applications in Alaska, yet would apply broadly to the east and west coasts and part of the coast of Florida. Here, Shell has identified an area where the statute is ambiguous. As a result, permits are delayed while EPA, the stakeholders, and the Environmental Appeals Board work to resolve these issues. I believe it would be appropriate for this committee to provide clarity on these matters. I hope we can work together to develop legislative language that would resolve those issues in an appropriate and targeted manner. But as we provide clarity, we must also realize these are large industrial facilities located off coasts where people live and in waters where people fish and whale. Shell's Discover operation emits more pollution than a 1,000-megawatt natural gas power plant and almost as much as a new oil refinery. Our goal should be to resolve this issue without sacrificing air quality. Shell has also raised concerns about the length of time of the permitting process. This is also an area where it's critical to strike the proper balance. The Clean Air Act has always provided for extensive and open stakeholder input to EPA's decision-making. This is a central principle of the law. It ensures that the government is responsive both to citizens who want clean air and to industry which wants to conduct activities that emit air pollution. While Shell has raised legitimate concerns about the permit process, the language before us goes too far. It eliminates the opportunity for any administrative review of EPA decisions, except for a narrow exception that would apply only to the permit application. It moves all judicial appeals from the regional circuit courts of appeals to the D.C. Circuit, and it requires EPA to issue final permits in 6 months, which will limit the time for public comment and may preclude EPA from developing the record necessary to support its final decisions in court. One effect of these changes would be to make it much more difficult for local citizens who are directly affected by air pollution from a project to raise concerns. Requiring Alaskans to fly to Washington, D.C. to challenge a permit decision is a real burden. Eliminating administrative reviews creates an additional hurdle for citizens. Administrative reviews are faster, less formal, don't impose fees, don't require a lawyer, and are often conducted by video conferencing. They also do not allow participants to recover attorney's fees. I'm also concerned about how this proposal will affect California and other states. In California, EPA has delegated the authority to issue permits for offshore oil and gas activities to local air pollution control agencies. The changes in this bill would override state and local interpretations, laws, and regulations that California has adopted to help meet its severe air pollution problems. It would also remove all appeals of California's permits from state hearing boards and state courts to the D.C. Circuit. This is a significant infringement of local control over local air pollution matters. I want to close with a comment on process. I am disappointed that EPA is not present to testify today. If we're going to reach consensus, we're going to need the input of the agency experts, as well as witnesses from California and other affected areas. Chairman Whitfield has today rejected our request. His position appears to us that it's reasonable to give the agency just a few days' notice and expect EPA to be able to send a witness to the hearing today. I understand Gina McCarthy is testifying today on a legislative matter before another committee. That's not fair. It's not how we treated administration witnesses in prior Congresses. For that reason, the Democrats on the committee are invoking our rights under Rule 11 to request a minority day of hearings. I believe scheduling our requested hearing will help the committee produce balanced legislation that achieves its stated goal and has a chance of enactment. I look forward to what the witnesses have to say, and we will withdraw that petition. Mr. Chairman, you indicated, well, you'll have EPA at other hearings. I don't know if it was meant other hearings on this bill or other hearings on other bills, but on this bill, we do want EPA, we do want other witnesses to be able to testify, and we are giving you that Rule 11.
Thank you, Mr. Waxman. This time, I would like to introduce the first panel.
Mr. Chairman, if I might, before we hear the first panel, Mr. Simpson has just shared with me a text or email that he received. The husband of our former member, Jane Harmon, Sydney, passed a few moments ago or earlier, and I would just want to inform all the members of the subcommittee and also invite them to keep the Harmon family in their prayers.
Thank you, Mr. Rush, and thank you, Mr. Shimkus, for letting us know about that. We're delighted to have these elected representatives on our first panel. They really do not need any introduction, but Representative Don Young from the state of Alaska, Senator Lisa Murkowski from the state of Alaska, and Senator Mark Begich from the state of Alaska. We know that that state is certainly impacted by decisions or lack of decisions made by EPA on air quality permits. And at this time, Mr. Young, I'd like to recognize you for 5 minutes for your opening statement.
Mr. Chairman, if I could, I'd like to go down the seniority role. I'm the senior member, but we do have two senators here, and they have lots of things to do on the other side. So at this time, I'd like to recognize Senator Murkowski, the senior senator from that side, and I'll yield to her, and then I'll take my time when she finishes.
Well, Mr. Young, you're being so kind today, which we appreciate.
If you take a look at my eyes, you know I am being kind.
Yeah. Well, Senator Murkowski, I'll recognize you for 5 minutes.
Thank you, Mr. Chairman, and I thank my colleague, Congressman Young. We're not going to suggest how many fights you get in on behalf of the state of Alaska, but you're playing the role here today. Mr. Chairman.
Do you have your microphone on, Senator?
Maybe I just needed it a little bit closer. Is that better? Thank you, Mr. Chairman. And ladies and gentlemen, thank you for your attention to this issue this morning. The fact that you have the full Alaska delegation represented here today, Republicans, Democrats, House and Senate, together to testify on this issue, I think speaks to the significance and the importance of this to those of us in Alaska. Congressman Young has recognized me as the senior senator, but I am also the ranking member of the Senate Committee on Energy and Natural Resources, as well as the ranking member on the Appropriations Subcommittee on Interior and the Environment. So we have been paying, of course, particular attention to this issue on the Senate side. You're going to hear some good testimony here today. But I think one of the most critical pieces that you will hear is the fact that America's most critical piece of infrastructure, the Trans-Alaska Pipeline, is now less than 1/3 full. The tremendous resources that are beneath Alaska's OCS could help us fill up that pipeline, slash America's dependence on foreign oil, create new jobs, and generate new government revenues at a time when we're all seeking those. And yet, despite these much-needed benefits, even exploration has been blocked because of the EPA's continued inability or perhaps simple unwillingness to issue valid air permits. You're going to hear the specifics of EPA's failure to comply with both the intent of the Clean Air Act and with Congress's directive in the fiscal year 2010 Interior and EPA appropriations bills. And I'll simply say, right at the outset, it doesn't really matter what your opinion is about offshore oil or gas development in the Arctic or elsewhere. It is absolutely indefensible for a permit application to take 6 years. 6 years when the EPA administrator has testified, as she did in my Appropriations Subcommittee, that there is no anticipated human health risk that is at issue. She has stated full out there's no human health risk here. So it's been 6 years and counting, Mr. Chairman, despite no anticipated risk. I would also suggest to the members of this committee that it's likewise indefensible to allow the EPA's failure to serve as a de facto veto over the national energy security interests of the Outer Continental Shelf. The OCS Lands Act assigns the Interior Department with the mission of the expeditious development of energy resources, and those resources belong to the American people, not to any corporation, and certainly not to any federal agency. It cannot be the EPA's decision nor their Environmental Appeals Board decision that determines whether Americans benefit from their holdings in the OCS. The EPA's core competencies are supposed to involve both an understanding of human health impacts and a command of air quality permitting regimes so that a regulated operation, be it a power plant, a factory, a drilling rig, can have a level of reasonable expectation about the timing of their application, especially when there's no human health risk at issue. Instead, we're witnessing core incompetency. The air permitting process has been confused and really taken advantage of by those who found the Clean Air Act to be less of an air quality statute and more of a hidden, blunt instrument that can be used to stop energy exploration. This is no longer a matter of understanding the process better or taking even greater steps to ensure air quality concerns are addressed. If the EAB cannot accept a permit that took this long and this much accommodation to issue, then EAB has no place in the process. And likewise, if the EPA can't demonstrate some competency, especially as congressional urging and intent becomes more clear, then EPA should not expect to keep its authority for long. Mr. Chairman, members of the committee, I'm grateful for the opportunity to testify to you, with you this morning. I do note the discussion going back and forth about the invitation to EPA to testify. I think it is an important issue and that EPA should be involved, and I think clearly an invitation to come and sit before you and provide that information is important. I will remind you, however, that given the very busy schedule that we have on the other side, Senator Begich and I were able to clear the decks with, I think, just about a day and a half notice. This is important to us. I would think that the EPA would think it is important to them as well. Thank you.
Thank you, Senator Murkowski. Senator Begich, you're recognized for 5 minutes.
Thank you very much. Thank you very much, Chairman Whitfield and Ranking Member Rush and the members of the subcommittee. Thank you for the opportunity to cross the Capitol to testify today, and congratulations on pursuing the American Energy Initiative. As our economy regains steam from the worst economic crisis since the Great Depression, developing America's energy resources for Americans and by Americans is a vital part of our recovery. About a month ago, President Obama proposed essentially that when he called for an increased domestic oil and gas development and cutting foreign oil imports by a third by 2025, the President even said in his administration is, quote, looking at a potential new developments in Alaska, both onshore and offshore. We Alaskans were glad to hear that the President used the word Alaska. As Americans' energy storehouse for better than a quarter of a century, we are anxious to continue supplying our nation a stable source of energy just as we have done since the oil starting to flow through the Trans-Alaska Pipeline in 1977. Simply put, Alaska has enormous untapped oil and gas reserves, an estimated 40 to 60 billion barrels of oil on state and federal lands and waters. That's approaching a decade worth of U.S. consumption. And we also hold the nation's largest conventional natural gas reserves, more than 100 trillion cubic feet of this clean burning fuel. There is no way you can do an energy plan without Alaska being part of it, for our economic security and our national security. As is always the case, it's the details that matter. While we welcome the President's interest in increased energy development in our state, his administration and those which preceded him have enacted roadblocks to this laudable goal. I know the hearing today focuses on offshore activity, but the problem is widespread. In the National Petroleum Reserve of Alaska, ConocoPhillips has been working for years to secure a permit to build a bridge into a petroleum reserve to develop oil, only to be stalled by the Army Corps of Engineers and EPA. In the offshore, Shell has been working for 5 years and now approaching 6 years, invested more than $3 billion for the opportunity to drill an exploratory wells in Alaska's Chukchi Sea. They've gotten very close last year, but just when it appeared the development had a green light a few weeks ago, an internal EPA Environmental Appeals Board sent the air quality permit back to the drawing board. Mr. Chairman, I have to confess that I haven't studied your bill closely, but I endorse the call for change. Business as usual simply isn't working when it comes to increased oil and gas development in my state. That's why I recently offered 2 relevant proposals to change. First, creation of a federal coordinator for the Arctic OCS. This would modeled after legislation the late Senator Ted Stevens passed, establishing a federal gas pipeline coordinator. This office would have the authority to work across the agencies, causing Alaska so much heartburn today: the EPA, the Army Corps of Engineers, and the Interior Department. The federal OCS coordinator would work with the state of Alaska and affected local governments to streamline development in the Chukchi and Beaufort Seas, which holds such promise for the future of oil and gas development for our state and for this country. Second, I would suggest, along with my colleague Senator Murkowski, that legislation to transfer the authority to regulate air quality and OCS oil and gas development off Alaska from EPA to the Interior Department, as is done in the Gulf of Mexico. Your legislation appears to make the EPA process work more like the Interior Department. Either way, we need to get to a place where one agency is in charge, where the process is the same across the country, and where people who invest time and money get a result on a reasonable time frame. Thank you for your efforts. As you see today, this is a combined effort by our delegation that Alaska oil and gas development is critical to our national energy portfolio, our national security, and our economic security. So we're just honored to be here. Thank you, Mr. Chairman.
Senator Begich, thanks so much for your testimony. Now, Mr. Young.
Mr. Chairman, much has been said in my statement by the 2 senators, and I won't repeat it. I ask unanimous consent to submit it for the record. Mr. Chairman, they both brought out the information. 5 years we've been waiting for a permit. We did get a permit from EPA, then the appeals board turned it down. In the continuing resolution we passed earlier on this year, we took away the authority of the appeals board to do so. And I think that's important, because we have gone through this, and really it's all about a ship. And this ship has put millions of dollars in make sure that they have clean air. And the EPA finally declared that they did have clean air, and the appeals board, on an interest group, turned down the permit. Another 5 years. But I want to go back to the concept of this nation and where we are today. I think you may have read the paper today, and the cost of fuel, and it will affect the economy. And by the way, the fuel in Chicago is about $4.36 a gallon now. It will be $5 by the 1st of July. Now, that does stifle this economy. And some people say we have to get off the fossil fuel economy. But in the meantime, I saw my president go down to Brazil and say, we're going to be your partners, we're going to buy your oil. Now, that doesn't make sense to me. It never has made sense to me when we spend billions of dollars to send money overseas, taking jobs away from Americans, and making us more dependent upon foreign countries to run our economy. You can't do that. We have a big budget battle going on right now. That budget battle has really been caused by the lack of being able to develop our fossil fuels. And by the way, don't buy this concept there's any shortage of fossil fuels. If you read the science, we have as much fossil fuels as most of the foreign countries do. And especially in Alaska, we figure there's 27 billion barrels of oil in Chuck Sea alone, probably 10 billion in Beaufort Sea. That's a tremendous amount of oil. Now, I'm not talking about Florida. I'm not talking about California or West Virginia or any other state. I'm talking about Alaska alone, with a pipeline right now is 1/3. Very nearly got shut down this last winter. It got shut down because we had a small spill that was controlled by the way the line was developed. And we were able to take and restart it. And by the way, you talk about the EPA. That is an agency that has run amok. They arrived there in Alaska and tried to tell the state that they were going to take control of it. It was their responsibility, and we could not start the pipeline without their okay. If it had been stuck down 2 more days, it would have froze that pipeline. The oil would not flow. And that's 12% of our economy today, our oil production today in the United States. It was at one time 25%. So I'm suggesting your legislation is long overdue. And don't, you know, the EPA is an agency right now that thinks that they can thumb their nose at you. I didn't thumb my nose at you. No, they care. They can thumb your nose at you and not answer questions. They should be here. Now, I can't quite understand that. Like you say, 17,000 employees, and they could send the janitor down. I think it'd be a good idea. Because what they say, don't you even touch us. We are now the authority. We are now the government of the United States, and don't you even question us. This so-called oil field is 70 miles offshore, and we're really talking about a rig, a drill ship, one ship, which would put all the efforts into it to make sure they got clean air. And to have an agency say, no, national security doesn't count. We're worried about the inhabitants, and by the way, the inhabitants, you're going to hear testimony later from one of them. But I've communicated, and I represent that whole state. There's 2 senators, 1 congressman. And you'll find out they work very hard. Shell's work very hard with Point Barrel and the other communities in those areas. And in fact, they have an agreement working together with the local communities. Now, of course, you're going to have dissent. We know that. Dissent usually fueled by outside interests, and we know that too. We fought this battle. And by the way, I'm the only person in this room that had the pipeline built in 1973. We passed that legislation out of Congress. Whatever we have to do in this Congress, if we want energy independence, we have to have that one provision I put in that bill. And that is a provision: there shall be no lawsuits by interest groups to stop a project in the name of national security. And we did that. We built that pipeline in 3 years. It is one of the greatest wonders of human construction that's ever been seen. And it's worked beautifully through earthquakes and other activities. It can be done. But we have to get oil back in that pipeline. And the one way we can do it is through your legislation. Thank you, Mr. Chairman.
Thank you, Mr. Young, and I want to thank all of you for taking time today. I know that you do have very busy schedules, and we appreciate your testifying on this important subject matter. Senator Begich, you made a comment which I certainly agree with, and that is that there should be one agency responsible for issuing these permits. And I would ask Senator Murkowski, do you agree with that or not?
I don't know that I would agree with that if the agency is the EPA. The EPA has demonstrated a level, the word that I used in my testimony was incompetency in this. When you have the administrator of the EPA admit in open record that in fact there is no human health risk and could not defend the fact that it has taken over 5 years to issue an air quality permit. Now, I would suggest to you that we need to figure out a way that we have a process that works. Look to how the process works down in the Gulf of Mexico, where the Department of Interior, through MMS or now BOMER, has worked to facilitate it. They have figured it out. It's 45 days on average to issue a permit there, 5 years plus by the EPA. So it's not just making sure that there's one agency in charge, but that there is an agency that has a competency to issue these permits.
Well, that's a good comment. I certainly agree with that. And I find it interesting that we are in this situation where we got Department of Interior issuing these permits in the Gulf and EPA everywhere else on the Outer Continental Shelf. And the fact that on the average it's taking Department of Interior 45 days, we do need an expedited process. And and I believe that they can make those decisions certainly in a quicker way than 6 years. I also have the one of the things that's disturbing me is that President Obama talks a lot about energy independence, and yet I get the clear impression that his cabinet officials, particularly at EPA, are doing the direct opposite of what he is saying. He talks a lot about green energy, and we know that somewhere down the road, green energy is going to play a major role in producing energy in America, but it is not there yet. And as Mr. Young said, we have so much fossil fuel in this country that this administration is doing everything possible to make it more expensive to burn fossil fuel. Even the Secretary of Energy made that comment. He said that gasoline prices should be more like what they are in Europe. So do you get the sense that this, the EPA, with this administrator, is a serious obstacle to America becoming independent on fuel issues? Yes, sir.
I'll respond. I think there is a disconnect from what the President says and what the agencies are doing. I mean, the example we just gave on the 5 years to get a permit, they're halfway through their lease. So they got less than 5 years to perform on that lease. So the economics of it now become even more difficult. And if you think about the whole issue of are we going to become less dependent on foreign oil of countries that are not our friends, and there's plenty of them that we're buying from, the only way you do that is you have to develop domestically. And I think there's, that's why I made the comments that I heard him say Alaska, which we're very happy he said it. The question is, will the agencies perform on that directive or that statement? And so far, that has not been the case, at least in my limited 2 years here in the Senate.
Yes, Senator Mikowski.
Mr. Chairman, you ask a very pertinent, very important question, and I would agree with my colleague that, in fact, the agencies are acting as an impediment to how we truly gain not only energy independence, but when we talk about national security interests, it's so integrally tied and related to energy. Congressman Young has mentioned the rising price of gas at the pump, and all of our constituents are coming to us and saying, what can you do to decrease that price, to lower the price? There's not a lot that we can do right here today to bring it back down below $3 from where we are right now. But there are some things that this president and this administration can do to keep the prices from going up. We might not be able to get them to go down, but let's keep them from going up. And what we're seeing right now with this level of agency kind of pile-on, if you will, it is keeping us from doing what we need to do as a nation to gain our own energy independence through increased domestic production. And whether it's the EPA regulations as they relate to emissions, whether it's the failure to advance a permit for a bridge so that we can access oil on the National Petroleum Reserve. These are agency decisions that are cutting off our ability for energy independence and raising the prices of energy to Americans all over the country, not just in Alaska.
It's my understanding that this platform out in the Beaufort Sea, if it started production, would be producing something like 1 million barrels a day. Is that right?
Beaufort Sea is not quite as large as Chuck Sea, but probably been 1 million barrels a day. We were producing 2.2 million barrels at one time out of Prudhoe Bay.
Okay.
And the plane has that capacity.
And if I might just add, Mr. Chairman, we have not given up on opening up Anwar, an incredible reservoir just to the east of Prudhoe Bay. That too could yield 1 million barrels a day. Now think about what that means to us and our economy and our jobs and our revenues into this country. $153 billion that this country could benefit from.
Absolutely. Mr. Rush, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I'm kind of bemused at the finger pointing at the EPA for especially coupling the EPA's activities with the activities of the Obama administration. As far as I recall, and you can correct me if I'm wrong here, I think the current EPA administrator has been in office for about 2 years, and as the witnesses, the senators who I really deeply respect, Chairman Young, who I deeply respect, they both have indicated that this permitting process has been delayed for about 5 years. So it seems as though the EPA under the Bush administration was the first one to delay these permits. Is that true?
I would suggest one thing. There's no administration to blame for the EPA other than the fact that Richard Nixon created it. Okay. And he created a lot of other problems, too. But the truth of the matter is I'm not laying this blame on the president, because I think there's a disconnect with the president and the EPA, but that's the creation of power that's been generated over the years. This is not the first time I've done battle with the EPA. They've been trying to insist on an arsenic quality in water on the Kenai Peninsula, where we put in a project 20 years because of the EPA, 20 years ago, to meet the standard, and now they come back and say you got to do it again with no science behind it.
I do understand. I just want to make sure that it seems as though there are some who who are trying to point their fingers at the president, and I don't think that the president is at this time is responsible for these delays. Now, let me just ask, and either of you can answer this, or all of you can answer this. I understand the EPA did issue permits, but they were invalidated by the EAB. Can you tell the committee the circumstances of why the EAB invalidated the permits, and whether or not you agree with those circumstances? What were the particulars?
I think you will get some additional testimony on this this afternoon, as just looking through the witness list here. But I think the simple story is that, in fact, a permit was issued. The EAB then came in and determined that the issuance of that permit was not supported because there had been subsequent changes to the EPA requirements. So in other words, you've been working on a process for a period of years. You get that through the process, the permit is issued, and then the EAB comes in and says, well, in fact, we've changed the rules, we've changed the requirements. In other words, we've moved the goalpost, and so this permit that was issued is no longer a valid permit. Again, there are clearly more details that I think will be spoken to later, but it was a situation where the rules were changed, I think, in the middle of the process. Again, thwarting the ability to gain a permit that had been in process for 4 years.
And if I can respond to Congressman, just to echo those comments, but also the bigger picture here is the amount of time it takes us compared to the Gulf of Mexico to do the same kind of operation even in some cases deeper water, clearly, higher pressure, clearly, than what we operate in and hope to operate in the Arctic. And I guess my point, and I agree 100% with Senator Murkowski that the goalpost was kind of moved down the line, but put that aside, for us to take this many years, maybe the ConocoPhillips development on the petroleum reserve established by the country.
Oh, with all due respect, I only have a few more minutes, and I have another point I want to make. And I just want to say that I'm concerned also about the length of time that these permits are taking. But on the matter of Administrator Jackson's statement that was alluded to earlier, I've looked at her statements about health impacts, and there's a context in which she made this statement. She did not say that these operations have no potential for health impacts. She was discussing the permit that EPA had granted, which required Shell to install air pollution controls. The EAB had asked EPA to provide better analysis showing that the final permit in fact protected local communities and satisfied environmental justice concerns. In that context, Administrator Jackson expressed confidence that further analysis will show that EPA's permit was in fact sufficiently protective. Nothing in her statement supports the notion that we can shortchange air quality protection because these sources don't threaten health. If we had EPA here, we could hear from them directly on this point, Mr. Chairman.
It's the practice of this subcommittee that when we have a panel of witnesses that are in the Senate or in the House, that the chairman and ranking member are the only ones who will ask questions. So I want to thank you all very much for taking time to be here. We look forward to working with all of you as we pursue this legislation. Thank you very much.
Thank you.
This time we'll call the second panel of witnesses. On the second panel, we have the Honorable Dan Sullivan, who is Commissioner of the Alaska Department of Natural Resources. We have Mr. David Lawrence, who's the Executive Vice President of Exploration and Commercial Development with Shell. How do you pronounce her name? Atandarock. We have Ms. Rosemary Atandarock, former mayor of Newquist, Alaska. We have Mr. Richard Glenn, who's the Executive Vice President, Arctic Slope Regional Corporation. We have Dr. Scott Goldsmith, who's professor at the Institute for Social and Economic Studies at the University of Alaska. We have Mr. Eric Graff, who's staff attorney for Earth Justice. And we have Mr. Robert Myers, who's senior counsel of Crowell and Mooring. I want to thank all of you for taking time to be with us this morning as we discuss this discussion draft. And at this time, Mr. Sullivan, I appreciate your coming all the way from Alaska, and I'll recognize you for 5 minutes for your opening statement.
Thank you, Mr. Chairman. Good morning. Representative Rush, good morning, sir. My name is Dan Sullivan. I'm the Commissioner of the Alaska Department of Natural Resources. I'm also a former Attorney General of Alaska, former U.S. Assistant Secretary of State with responsibilities over global energy, finance, and economic issues, and I'm currently a U.S. Marine Corps Reserve officer as well. Mr. Chairman, I've submitted extensive written testimony for the record and would like to briefly touch on the main points. Our country faces very serious energy security challenges, and Alaska can and should be able to play a significant role in partnership with the federal government in helping our fellow citizens address these challenges. Unfortunately, right now, that is not happening, and I'd like to explain that in a little bit more detail. Alaska is home to one of America's most vital components of energy security infrastructure, the Trans-Alaska Pipeline System. As Congressman Young stated, Congress played the critical role in the creation and rapid construction of TAPS. You are the godfather of this critical American asset. Unfortunately, your godson sits 2/3 empty from its peak of 2.2 million barrels a day down to 640,000 barrels a day and declining. Working together, we are confident that we can fix this situation and further promote America's energy security. First, as was already mentioned, the North Slope of Alaska, by any measure, both on and offshore, remains one of the world's most productive hydrocarbon basins, with estimates of conventional and unconventional oil in the billions of barrels and estimates of gas, natural gas, in the trillions of cubic feet. Second, Alaska is one of the most environmentally stringent places on Earth to explore and produce hydrocarbons. We are also one of the world's top innovators of safer environmental technologies. And third, the state of Alaska is doing all it can to reverse the TAPS throughput decline with a comprehensive set of reforms that include significant tax and fiscal reform, permitting overhaul, and the creation and construction of new infrastructure projects. But we are missing a critical partner, Mr. Chairman, and that's the federal government. The federal government's policies in Alaska have shifted from helping us protect our environment, which we support because we care deeply about it, to proactively shutting down resource development. Now, this is not just rhetoric. As Senator Begich said, this is a widespread problem in Alaska. If you look at pages 13 through 18 of my written testimony, I provide 7 specific examples in less than 2 years where the federal government has made decisions that will stall, kill, or delay resource development on state and federal lands in Alaska. This anti-development posture by our own federal government is the cause of enormous frustration and anger for a vast majority of Alaskans. Now, the state has done all it can, countless meetings, letters, public comments, testimony, and yes, even suing our own federal government to dissuade the federal administration from pursuing and continuing locking up Alaska's resources. Why? Because we believe in doing so, locking up the resources, it not only hurts Alaskans, it significantly undermines broader American interests. Rarely has there been a federal policy that fails on so many fronts. Jobs and economic growth, energy security, the national trade deficit, the federal budget deficit, and national security are all undermined when Americans are prevented from producing energy for our own citizens from the largest resource basin in the country. Ironically, this policy also undermines global environmental protection because it drives resource development overseas to places like Brazil, Russia, Saudi Arabia, Kazakhstan, Azerbaijan. Mr. Chairman, I've been to all these countries. This committee can be sure that they do not have nearly the stringent environmental standards that we have in Alaska. But my main purpose in traveling from Alaska today is not to complain, but to redouble our efforts to achieve the federal partnership that we believe is so critical for Alaska and America's success. So in closing, Mr. Chairman, I believe there are 3 important things Congress can do. First, support Alaska's goal of 1 million barrels of oil through taps within 10 years. Attached at the end of my written testimony is a recent letter from Governor Sean Parnell of Alaska to President Obama, asking the President to support this ambitious goal which Governor Parnell laid out last week. We believe that Congress should make achieving this goal a national priority, 1 million barrels of oil through taps within a decade. Second, continue to work on permitting reform to expedite and bring certainty to federal permitting decisions. During World War II, America built the 1,400-mile Alcan Highway in less than a year. Today, a project like that would take 5 years just to fill out the EIS application. And finally, Mr. Chairman, Congress should continue its vigilant oversight role of federal agencies that make resource decisions in Alaska. As a former Attorney General, I believe that some of these decisions are made with little regard to Congress's declared national policies and federal law, and I think it's important to recognize that. Thank you very much, Mr. Chairman.
Mr. Sullivan, thank you very much. Mr. Lawrence, you're recognized for 5 minutes.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to speak to you today. I've been asked to talk about Shell's Alaska exploration program and the regulatory challenges that have blocked it.
Is your microphone on, Mr. Lawrence?
Thank you, Mr. Chairman. First, let me make 3 points. Our nation needs oil and gas. Second, Alaska's outer continental shelf has world-class resources. Third, developing these resources has broad and long-term benefits. It is widely recognized that the world's demand for energy will double by 2050, and to meet it, we will need all forms of energy. Government estimates say Alaska's offshore holds at least 27 billion barrels of oil, and it may be much, much more. We can't know until we can actually explore with the drill bit. We've been ready to do that since 2007.
However, we've been blocked by regulatory barriers. One of the most frustrating, the inability to get a usable air permit from the EPA. This is a concern for Shell, but more importantly, it's a concern for the nation. Put simply, Alaska's OCS is an imperative for energy supplies, the economy, and national security. Developing Alaska's resources will contribute substantially to meeting the energy needs of America's consumers and America's businesses. It's not unreasonable to assume that production from Alaska's OCS will reach 700,000 barrels per day for 40 years. That's equivalent to the 2010 oil imports from Iraq and Russia combined. In 2030, some have estimated that peak production could be over 1.4 million barrels per day, and that's more than our 2010 imports from either Saudi Arabia or Nigeria. Reducing foreign imports has immediate economic benefits. The balance of trade will improve. U.S. dollars will remain here in our own economy. Alaska's OCS development will create an average of nearly 55,000 jobs per year for generations. These are long-term, well-paying jobs, both in Alaska and in the lower 48. It will generate conservatively $197 billion in government revenue from royalties and taxes. The oil will move through the Trans-Alaska Pipeline, which continues to be a major supply line to the lower 48. Without additional production in Alaska, this critical infrastructure will collapse, and we cannot stand by and allow this. Regulatory barriers that undermine the nation's oil and gas leasing program should be a concern to policymakers. Consider the facts. At the government's invitation, Shell participated in offshore lease sales in Alaska. We paid the government more than $2 billion for those leases and invested more than $1.5 billion to prepare for an exploration program that meets and exceeds all regulatory requirements. But despite our most intense efforts, we have yet to drill a single well. This is highly unusual. When the federal government holds a sale, it is saying OCS exploration and development is desired. If a company presents a plan that meets all regulatory requirements, that plan should be permitted. Unlike a development and production program, exploration here is a temporary, short-term operation. Our initial Alaska wells will each take just 30 days to complete. Data will be gathered, and the well will be permanently plugged and abandoned. These are not complex wells. The wells in Alaska's OCS are vastly different from those in deeper water, specifically in terms of water depth and reservoir pressure. Much lower pressure means the mechanical barriers in Shell's well designs will have even greater safety margins and much lower risk profiles than we see elsewhere in the deepwater Gulf. Still, Shell has assembled an unprecedented oil spill response capability. And there is no question that the bar should be high in the Arctic. We support high standards and a robust permitting process. But the process must work, and the EPA permitting process has failed. The emissions from our program pose no threat to human health. The EPA administrator herself stated this during a recent Senate hearing. No company should endure the delays and waste we've experienced over the last 5 years. Certainly, this is an area that Congress should address. First, Congress should clarify where emissions from an OCS facility should be measured. For onshore facilities like a manufacturing plant, emissions are measured generally at what is referred to as the fence line. Offshore drilling ships have no fence lines, and the public is many, many miles away. Second, Congress should provide a clear definition for the point in time when a drilling vessel becomes regulated by the Clean Air Act. And third, Congress should require EPA to take final agency action on an OCS air permit within 6 months of receiving a complete application, and should centralize any potential judicial review of final permits in the D.C. court. Thank you, and I look forward to answering your questions.
Thank you, Mr. Lawrence. Ms. Oktungarak, you're recognized for 5 minutes.
Chairman, ranking members, members of the committee, thank you for the invitation to participate in today's hearing.
Would you move the microphone a little closer?
My name is Rosemary Otongarok, and I have lived on the coast of the Arctic Ocean for most of my life. I recently moved to Barrow, Alaska from Nooksett, Alaska. I have served as mayor on numerous councils and organizations related to tribal leadership, and for a long time as a community health aide. I am testifying on behalf of Alaska Wilderness League. I am here to tell you how oil and gas development affects those of us who live on the Arctic slope. This bill you are considering to allow the oil industry to sidestep regulations on pollution as set forth by the Clean Air Act will have a devastating impact on my people who have called the Arctic home for thousands of years. If you allow this bill to move forward, you are telling me and everyone who lives in the Arctic that we, proud Inupiats and Americans, are less important than a few foreign-owned oil companies like Shell Oil. Shell's proposed 2010 activities in the Chukchi Sea, much of which would be exempt under this law, would have released as much pollution as 825,000 cars driving 12,000 miles in a year. And next year, they are looking to more than double their proposed activities. Emissions from the ocean-going vessels that Shell is proposing to use include major contributors to global climate change. It has been well documented that air pollution travels long distances, and Shell's 2009 application for drilling permits showed that operations in the Arctic's Chukchi Sea could cause significant health impacts to Arctic slope communities. We are rightfully concerned about the ramifications of these emissions and the overall actions as proposed. Currently, the oil fields across the North Slope emit twice the amount of nitrogen oxide as emitted in Washington, D.C. All onshore North Slope communities would be additionally impacted by Shell's offshore proposal, including my former home of Nooksett, just west of the Arctic National Wildlife Refuge. Nooksett is already surrounded by oil pipelines from the Alpine oil field, less than 4 miles away, and the yellow haze can be seen for miles and miles. During winter, there are many natural gas flares. As a result, I spent many busy nights on call responding to the community members' complaints about respiratory illnesses. Our people have markedly higher rates of pulmonary disease than the general U.S. population and may have genetic predispositions to disease that differ from other U.S. populations. Our people are substantially more vulnerable to morbidity and mortality from air pollution than are other Americans. When I started my career as a health aide in 1986, there was only one asthmatic patient. Then oil and gas was still many miles away. When I took my first break in 97, there were 60 people who had to use respiratory medications. Industry got much closer to my home. For this village of more than 500 people, a 600% increase in respiratory patients should get some type of response. Yet our voices continue to be ignored. Watching the eyes of babies fighting to breathe tears into you. Families have to fly sick children out of the village to Barrow or Anchorage. Knowing that the family has to send a parent with the child, what does it take from the family and the community? Our people depend on a lifestyle and diet that is radically different from other U.S. populations. I live a very traditional lifestyle, hunting, fishing, whaling, gathering, and teaching my family and community members the traditional and cultural activities as my elders taught me. The land, sea, and air provide for us through the long, dark winters. Because of this, the Inupiat culture is intricately tied to the Arctic Ocean, and our exposure to pollution comes from both our time on the land and on the water. We spend much of our time on the water fishing, hunting, and otherwise feeding our families. Our hunters and fishermen are out on the ice in the winter all year long. In the springtime and summer, we're out hunting for seals and preparing for the whaling season. In the fall, we are fishing and whaling. When the water freezes, we are preparing the well for storage and preparing for the feasting and sharing. Our people have used the Arctic Ocean since time immemorial for our subsistence practices. We don't just stay on land. Yet, despite the direct effects on our communities, this bill would also limit how my people meaningfully participate in the clean air process, while explicitly preserving the industry's right to appeal these same decisions. The federal government has continually failed in their responsibility to conduct government-to-government consultation with my people. This bill would even more severely limit our voice in the process that directly affects our well-being. The Arctic Ocean is our garden. For thousands of years, we have stood watch over this garden and the animals that live in it. I ask you now, please don't keep us from fulfilling our sacred duty to protect this place and pass it on to our future generations.
Thank you. Mr. Glenn, you're recognized for 5 minutes.
Thank you. Can you hear me? Chairman Whitfield, Ranking Member Rush, and subcommittee members. My name is Richard Glenn, and I live in Barrow, Alaska. I'm Executive Vice President of Lands and Natural Resources for the Arctic Slope Regional Corporation. The Arctic Slope Regional Corporation is one of the 12 land-based native regional corporations created pursuant to the Alaska Native Claims Settlement Act of 1971. ASRC owns approximately 5 million acres of land and is owned by the 11,000 Inupiaq Eskimo shareholders that mostly reside in the 8 villages of Alaska's North Slope. This discussion is timely. Right now, our region is preparing to assemble our leadership on this very topic, and we find that this issue boils down to community survival. Our villages are small and they're separated by great distance. No roads connect our villages. Barrow is located 340 miles north of the Arctic Circle, near the boundaries of the Chukchi and Beaufort Seas. We might not be able to see Russia from our front window, but we can sure see the changing Arctic and the Chukchi and Beaufort Sea. This is a region of tundra plains. It's devoid of trees. The average temperature in winter well below zero. In Barrow, where I live, the ground is frozen down to about 1,000 feet below surface. In our remote village, fuels can cost more than $10 a gallon, milk $11 a gallon, diapers $22. Despite these challenges, as my friend Rosemary has said, the Inupiat have endured for centuries. We have a close relationship with both the land and the sea. In my lifetime, our communities have gone through great change. Today, our villages are really small cities. They have small city needs, power plants, water and sewer facilities, health services, fire protection, roads, and schools. Our people depend on these services, which are provided for by our home rule municipality, the North Slope Borough. It's the largest county in the country. It's based on locally derived property taxes that they are based on oil and gas exploration in our region. There's essentially no other economy in our region. The volume of oil being produced in Alaska is in steep decline, as this committee has heard. This threatens the future of our communities and our culture that we have worked so hard to sustain. We have asked ourselves, what will our grandchildren do? Where will they go to school? What will power their villages? We understand that current onshore resources are not enough to stem the decline in production, which directly affects our communities. It may seem odd to some of you that Eskimos in northern Alaska are seeking ways to increase the volume of oil moving through the Trans-Alaska Pipeline, but here we are. Safe and responsible oil and gas development is the only industry that has remained in our region long enough to foster village improvements. We have coal, natural gas, and oil, and in some places in our region we have them in great abundance. Development of these resources is critical to our survival. The people of the North Slope also have a heightened concern for the environmental effects of oil and gas exploration and development. No one has more than we do regarding environmental risks. The animals that we depend on for our food and our culture migrate over large ranges in the land and in the ocean. Like most of my fellow community members, I depend on them. I depend on the sea resources for sustenance. I've served as a co-captain in my extended family's whaling crew. In studying the issues related to offshore development, we focused on safety and prevention, and we were favorably impressed by the timing, the technology, and the safeguards introduced by Alaska's OCS explorers. Our eyes are open on this issue. We know there are risks, and we believe they have been mitigated appropriately. Regarding air quality, we note that the exploration areas in the Arctic are more than 50 miles away from the nearest community. There are also significantly fewer drilling operations envisioned for the Alaska OCS than the Gulf of Mexico. We question why, despite these differences, there are Clean Air Act requirements that apply to OCS sources in Alaska that don't apply to the same sources in the Gulf of Mexico. Thank you for giving this important issue your attention. Our intent is to remain at the table with both government and industry. Let me be clear. Without development in our region, our communities will not survive. Please allow us to meet our responsibilities to our grandchildren and future generations. As Congress goes forward and debates this issue, remember the impacts your decisions will have on our communities, our culture, and our people.
Thank you, Mr. Glenn. Dr. Goldsmith, you're recognized for 5 minutes.
Thank you, Chairman Whitfield, Ranking Member Rush, and committee members. My name is Scott Goldsmith. I've been a professor of economics at the University of Alaska for 35 years and recently co-authored a study of the economic effects on the state from development of the oil and gas resources from the OCS off the North Shore of Alaska. Funding for the study was provided by Shell Exploration and Production. I'm testifying on my own behalf and not as a representative either of the university or Shell. In 2006, the Department of Interior, MMS, estimated that the undiscovered economically recoverable oil in the Beaufort and Chukchi Seas was 12.5 billion barrels, assuming $60 as the price of oil, more than the initial estimate of recoverable oil from Alaska's Prudhoe Bay field, the largest ever discovered in North America. The economically recoverable natural gas was estimated to be 50 trillion cubic feet. Industry interest in the Alaska OCS was reflected in 3 recent lease sales. 2 sales in the Beaufort Sea in 2005 and 2007 generated $367 million in bonuses and 1.1 million acres leased. The Chukchi sale in 2008 generated $2.3 billion in high bids and 2.8 million acres leased. Development of these resources could result in production of more than 1 million barrels of oil a day for more than a generation. This could reduce foreign imports, currently 10 million barrels per day, by 10% and improve our balance of trade by $36 billion a year, assuming $100 per barrel of oil. Of course, there are many technical, economic, logistical, environmental, and other challenges to achieving that production goal, and under the best of conditions, it would take nearly a decade to reach first production. At the time our study was done, we projected that production could begin in 2018. Today, first production is still at least 10 years away in 2021. Petroleum has been the most important economic driver for Alaska since it became a state in 1959. The economy today would be half as big without petroleum and hard-pressed to support a basic level of services for its citizens. Without petroleum, about 60% of all jobs would be dependent on the federal government. 16 billion barrels of oil has been produced from state lands on the North Slope over the last 35 years, but the largest fields, Prudhoe Bay and Kaparak, have been in decline for 20 years. Development of nearby small fields, hard-to-reach reservoirs, and unconventional reserves face economic challenges, and all projections are for continued decline in onshore production. Because of this, the state faces an uncertain future. Providing industry access to petroleum reserves on federal lands offers the best path to continued economic prosperity for the state. OCS development could add an annual average of 35,000 jobs to the Alaska economy over the next 50 years, offsetting the likely job loss from the continued decline of production on state lands. These would be high-paying year-round jobs with a combined payroll of $75 billion. These jobs and the sales of Alaskan businesses providing support activities could be the foundation for a sustainable economy for the state for more than a generation. Under current law, the federal government retains essentially all the public revenues from leases, bonuses, and royalties from the Alaska OCS. We estimate state revenues of $17 billion spread over 50 years. Local governments directly impacted by development would receive $3.5 billion over that same period. These revenues would be small compared to current state spending, but large compared to the communities on the North Slope. Alaska OCS development could also generate annual average employment of 28.5 thousand in the rest of the U.S. and substantial revenues. At an oil price of $100, federal revenues from royalties, income taxes could be $226 billion over the next 50 years. State and income and sales taxes outside Alaska could be $7 billion. Moving forward with the Alaska OCS would enhance the potential for further development of Alaska's other petroleum resources. Alaska OCS development would enhance the viability of a gas pipeline to supply Alaska natural gas to the lower 48, because it would increase the amount of gas available to a pipeline. OCS oil flowing through the Trans-Alaska Pipeline would keep the cost of transportation low, enhancing economic viability of smaller onshore reserves. It would extend the useful life of the pipeline that some suggest is in danger of shutting down from technical challenges. It would increase the options for development of unconventional resources. Delays in development put these opportunities at risk. Because of petroleum, the Alaska economy has remained relatively strong through the recent recession. But oil production today is only 1/3 the level of 20 years ago and continuing to fall at 6% a year. Looking forward, Alaskans are asking what will sustain the economy for the next generation and understandably concerned. Moving forward with OCS development would be a strong positive signal that opportunities exist for a strong economic future for the state and its citizens.
Thank you very much, Mr. Graff. You're recognized for 5 minutes.
Thank you very much. Okay. Thank you very much, Mr. Chairman, members of the committee. Thank you for inviting me to participate in today's hearing. My name is Eric Graffey, and I am an attorney with Earth Justice, a national public interest conservation law firm. I work and reside in Anchorage, Alaska. By way of background, America's Arctic Ocean has sustained human communities for thousands of years and is home to some of the world's most iconic wildlife species. However, fundamental gaps exist in our basic scientific understanding of the region. Further, global warming is transforming it dramatically. In recent years, offshore oil and gas activities have also increasingly threatened the Arctic Ocean, as permitting and planning decisions have been rushed forward without adequate baseline data, coordination, public involvement, or oil spill planning. The bill under consideration today would add another threat. It seeks to create a loophole for offshore drilling in the Arctic Ocean by exempting it from the important protections of the Clean Air Act, one of the country's bedrock human health laws. This is no trivial matter. To put it in context, when Shell Oil Company proposed exploration drilling in the Chukchi Sea in 2010, its operations alone would have emitted roughly as much carbon dioxide as the annual household emissions of 21,000 people, or roughly 3 times.
Mr. Graff, excuse me, could you move the microphone a little bit closer?
Sure. Okay, it's got to be very close. 21,000 people, or roughly 3 times the entire population of Alaska's North Slope borough. And that's just one drilling company drilling wells in one summer's drilling season. I'll focus on 2 of the most harmful provisions of this bill. First, the bill seeks to exempt the great majority of emissions from Arctic offshore drilling from stringent pollution controls. In the Arctic, the lion's share of pollution from offshore drilling is caused by vessels that accompany the drill ship, like icebreakers, not from the actual drill ships themselves. In Shell's proposed 2010 drilling, for example, up to 98% of air pollution came from Shell's associated vessels. This bill seeks to exempt those vessels from the Clean Air Act's Prevention of Significant Deterioration program. The program, as its name suggests, is intended to prevent existing air quality levels from deteriorating. In 1990, President Bush signed into law amendments to the Clean Air Act that applied the PSD program to offshore oil drilling. The program has 2 main tools for reducing air pollution, requiring that industry not violate quality standards and requiring that it apply best available control technology to reduce its pollution. This bill would count emissions from associated vessels and icebreakers in determining whether drilling operations trigger the PSD requirements, but then it would exempt those vessels from those requirements. It would apply the requirements only to the drill ship, but icebreakers are the major source of pollution from offshore Arctic drilling. And these emissions are a health concern. For example, in Shell's proposed 2010 drilling, icebreakers and support vessels could have emitted over 1,000 tons of nitrogen dioxide, a toxin for which even short-term spikes in concentration can prompt asthma, bronchitis, emphysema, and pneumonia. The bill would make it law that the oil industry does not have to apply the best available control technology to these or any other pollutants coming from its icebreakers. It would seriously undermine the purposes of the Clean Air Act and the PSD program. Weakening health protections in the Arctic is particularly troubling because communities along the North Slope of Alaska have markedly higher rates of pulmonary disease and are substantially more vulnerable to mortality from air pollution. For example, rates of chronic lung disease on the North Slope are dramatically higher than in the general U.S. population. Second, the bill seeks to limit the public's participation in decisions about pollution from offshore that directly affect their health. For example, it would prevent citizens from seeking an administrative review of permits, but would preserve that right for oil companies. And it would limit the amount of time EPA has to grant or deny an air permit application. Again, these provisions are particularly troubling in the context of the Arctic, because many of the communities most directly affected by Arctic offshore drilling decisions are remote and unconnected to the road system. These communities, moreover, will bear the vastly disproportionate burden of the pollution from offshore drilling. If anything, they should be given more time and opportunity to engage in meaningful public participation about decisions that disproportionately affect them. Instead, this bill significantly weakens those rights. Protecting the Arctic and its people from air pollution that directly threatens human health and contributes to already rapidly changing climate in the region should be of the highest concern. This is what the Clean Air Act and the 1990 amendments were meant to do. This committee should not weaken these protections. It should reject this bill. Particularly in light of last spring's Deepwater Horizon oil spill, Congress should focus on facilitating a renewable energy future and science-based protective management of the Arctic Ocean, not on creating loopholes for offshore oil drilling in the region. Thank you very much.
Thank you. Mr. Myers, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Members of the committee, appreciate the opportunity to testify. As with any sort of matter of this nature, I think it's first appropriate to look at the legislative history of this provision. My written testimony contains some of that. I don't pretend that's comprehensive, but with respect to where 328 came from, there's precursor legislation in the House and the Senate. These bills seem to basically have been addressing situations off the coast of California in the 1970s and 1980s. And we're focused primarily with respect to the onshore impact of the emissions. But in any event, when we look at the history here, Congress settled the issue of how it wanted to regulate OCS sources through enactment of Section 328 of the Clean Air Act. Now, in one sense, I think that's what Congress intended to do in the Clean Air Act, but this testimony received otherwise. I think it's clear that the matter seems to be very unsettled. Various interpretations with regard to the Clean Air Act have been offered up to the regional office. Various interpretations of the Clean Air Act have been offered up to the EAB, and the EAB has issued a very lengthy opinion on the same. So I would emphasize, too, that under the process that EPA is following right now, the permit at issue here for litigation, or potential litigation, I suppose, would be the frontier discovery, and that's not considered to be final. But I think this situation stands in stark contrast to what Congress and EPA seemingly intended by enactment of Section 328 in the first place. If you look at EPA's OCS regulations, right in the beginning, they state, in implementing, enforcing, and revising the OCS rule and in delegating authority hereunder, the administrator will ensure that there's a rational relationship to the attainment and maintenance of federal and state ambient air quality standards, and the requirements of that, and that the rule is not used for the purpose of preventing exploration and development of the OCS. This is in the EPA regulatory text. In proposing the OCS regulations in 1991, EPA stated that it intends that the proposed OCS rule will result in a more orderly, less burdensome system of air quality permitting process for OCS sources. This may certainly speed up the permitting process, which may reduce costs in some instances, particularly offsetting the additional costs associated with the rule's more stringent requirements for controls and offsets. I think the fact that it's taken years to decide matters concerning the operation of drilling ships in the Arctic demonstrates that EPA's intentions, at a minimum, have not been fulfilled. My written testimony also recounts the various efforts under Title II of the Clean Air Act regarding the control of emissions from marine vessels. As my testimony recounts, EPA has been aggressively addressing such emissions for over a decade and will continue to implement standards and new fuel requirements over the next decade. These regulations did not exist in 1990 when Congress enacted 328 and represented a significant change in circumstances from those that Congress sought to address. These regulations affect all classes of marine vessels. These regulations affect new vessels and remanufactured vessels. These regulations affect fuel sulfur levels that are used. And the U.S. has further, as I point out in my testimony, entered into international negotiations with respect to the control of fuel off the coastlines. All these factors are new. All these factors did not exist in the 1990s, and all these factors will affect vessels. With regard to the discussion draft, The legislation essentially has three substantive sections. With regard to air quality measurement, it adds a specification the air quality impact of the OCS source will be measured with respect to the corresponding onshore area. My interpretation of this is that it's consistent with the language and legislative history of the Clean Air Act. Now, I know that's been a matter of contention in terms of the current permit, but I think it maintains the proper focus of NAAQS, which has been, with regard to a primary NAAQS, a focus on protection of public health with an adequate margin of safety. Now, with respect to the OCS source definition, the section provides that direct emissions of the vessel servicing an OCS source shall be counted, but shall not be basically subject to as a stationary source under a PSD program. I think I would fundamentally disagree that the Clean Air Act requires that vessels install BACT. This position does not appear in the legislation. This position, in fact, in the EAB decision with regard to the Frontier Discovery Permit, the EAB agreed that vessels are not within the ambit. This decision also is reflected in the 1991 regulations. And finally, just with regard to EAB itself, as I note in a footnote in my testimony, I would point out that the agency considers that the existing statutory deadlines in Clean Air Act do not apply when the EAB is considering a permit.
Oh, thank you, Mr. Meyer, and thank all of you for your testimony. Mr. Lawrence, what was the date that you all signed for this lease? What day did you acquire this lease?
We've had multiple lease sales. The first one was in 2005. We had subsequent one in 2007, and then subsequently in 2008, and that was the big one in the Chukchi. At that, Mr. Chairman, we bid record amounts, $2 billion, and we did that because what we saw is the tremendous resource potential.
Now, I heard if you had this air permit issued tomorrow, what would be the time frame for you to start production of oil?
At this point in time, we'd be looking at something that would start probably in the middle of the next decade. And I point that out for the following reasons. If we had been allowed to begin at the time that we thought we would start when we received these permits, we had hoped to start at the early part of the next decade or even in this decade.
And if you had the air permit tomorrow, how many additional permits would you have to have before you could start production?
We've currently worked right now with 35 permits to be able to work through this, so there's a large amount of coordination between different agencies to be able to do that. We've made satisfactory progress on most of those permits, and we expect that we will be able to work through those. However, there's always the chance that some of those may not come.
But you need a total of 35.
35 permits to be able to drill.
Now, it's my understanding, Mr. Meyer or someone on the panel, that this EAB board was not really in the Clean Air statute, but was simply created by one of the administrators of EPA. Is that correct?
That's correct. It was created under regulations issued by EPA. It is, in fact, a part of EPA, and so it's a regulatory creation.
Okay. Now, Mr. Meyer, would you be able to explain the primary differences between the criteria to issue a permit by the Department of Interior for OCS production and the EPA process?
Well, the current regulations that DOI apply do require under 1334A8, I believe, of the regulations that the DOI apply national ambient air quality standards. With regard to how EPA addresses it, they're acting under authority under 328. And effectively under 328, what they're doing is applying other parts of the Act. If I might parenthetically assert here, I don't read the legislation to exempt the sources from the Clean Air Act. The legislation effectively interprets certain provisions within 328, but it doesn't exempt the OCS source from PSD back review. That's maintained.
Okay. Ms. Atangarak, you had mentioned in your testimony that you opposed this legislation, and what particular part do you object to?
The exemptions to industry to allow them to increase the pollutions in our area is that, and also the push to allow industry to move forward with their process for bringing concerns into the right process where we would be limited as local citizens.
But the exemptions, and Mr. Meyer, you said there are no exemptions, is that correct?
No, it doesn't exempt OCS sources from PSD back review.
Mr. Chairman, I have
Yeah, Mr. Croft.
Thank you very much. As Mr. Myers said,
Mr.
Myers said, the provision would still regulate and apply PSD to the OCS source, which it would define as the drill ship, which produces maybe 2% of the pollution from Arctic offshore drilling. Most of the pollution from Arctic offshore drilling comes from the associated vessels, which this particular piece of legislation seeks to exempt from the application of best available control technology and the other PSD requirements, as I think.
Do you agree with that, Mr. Myers?
They never were included under BAC. They're mobile sources. Title II of the Act regulates mobile sources. Marine vessels are non-road sources, as I point out in my testimony. I think it's a misinterpretation of the Clean Air Act to say that BAC applies to a mobile source.
Okay.
Your Honor, may I respond?
Yes.
The Section 328, when it was passed, directed that the PSD program be applied to OCS sources, and as written when it passed, it said apply PSD and back to OCS sources. Direct emissions from the associated vessels, like icebreakers, are direct emissions from the OCS source. It would seem odd to determine to look at those emissions from a policy perspective, to look at those emissions when you're determining, well, does the PSD program apply?
My time has expired, but I'm assuming you would disagree with that, Mr. Meyer, but don't just say yes or no.
Absolutely.
Okay. This time I recognize we'll meet afterwards and we'll get you two together and we'll talk about it. Mr. Rush, you're recognized for 5 minutes.
Mr. Chairman, I might, if I could, remind the committee that this is the Shell's operations and the matter that these witnesses are discussing and pointing to will be the first in the Arctic waters, and it's important that we get the environmental and public health protection right in this instance. And Mr. Chairman, I want to remind you and other members, especially from my Republican friends, that might just don't make it right. This bill is designed to help one company get permits to drill, but standards set by this committee will apply to all future offshore projects in the Arctic as well. And Mr. Chairman, I again want to reiterate my concern that if the EPA had been here today as a witness to describe how this bill will affect public health and the environment in the Arctic over the long term, as more oil companies attempt to deal in the delicate Arctic ecosystem, then we might be further along and we might be able to get this right. My question is directed to Mr. Graff. Mr. Graff, can you speak to the cumulative health impacts of offshore oil and gas drilling as more companies enter the Arctic waters?
Yes, thank you. Shell is the first one that would be out there, and its pollution alone was significant and taking up very high, up to 70 or 80% of the allowable increments that you're allowed to sort of add air pollution into the air. And that's just one operator, and there are other operators who have announced plans to attempt to get drilling permits starting soon. And so it's a big problem because one operator's taken up all the space and polluting a whole lot, and as more come, there will be much more pollution.
Ms. Arctic-Rock, can you talk about some of the impacts that you've seen regarding climate change and air pollution on the ground in the Arctic? region?
We're definitely seeing some changes to the Arctic. For us, one of the important concerns is whether or not the caribou are going to cross the rivers to get to the calving grounds, whether or not there's going to be appropriate growth of vegetation for the calves that are going to help with their survival rates and their health, whether or not there's enough insects that are produced for the birds when they migrate up for their new growth of their young ones, whether or not there's adequate ice for us to go out and do our traditional cultural activities, under ice fishing. If we don't have the ice forming the way it's supposed to, we may not get the fish when we want to get them, when they're available to us, when we can get like before the eggs hatch, those kinds of things. Whether or not we're going to have the platforms to bring the ice up, the whale up onto the ice. Those are all very important concerns. Whether or not we're going to have ice on the shore during the fall storms. Those things affect the erosion rates along the coast tremendously, and it's already caused tremendous problems. The increased rains are affecting us. We're having tremendous amounts of erosion, especially on the Colville River. There's areas that I've seen over 500 feet eroded in just a few years. It affects the air in general, whether the way that the particles are in the air, how it affects us and our health. Some of these things have not been well studied. The particulates in our environment most of the studies are at 70 degrees. We don't have many days at that temperature. There's a lot of effects that go there. For health concerns, as a health aide, when I started, I was taught by our people what is normal. I didn't used to hear a lot of wheezing in patients. I had one person who used an inhaler, but as I continued to work and further my education, I started counting these things. When I came back from PA school, there were 35 people that were having to use medications.
Thank you so very much. We're getting the picture. I want to move on because my time is winding down. Mr. Graff, the question is, are you opposed to any drilling in the Arctic region, or are you, and is there any satisfactory level of controls and protection that will satisfy you in terms of the drilling in the Arctic region at all?
We're not against drilling in the Arctic region. We're for the application of environmental laws to that drilling to protect human health and to protect the natural wildlife resources of the region.
Mr. Chairman, I yield back.
Mr. Shimkus, you recognize 5 minutes.
Thank you, Mr. Chairman. Press reports indicate that Administrator Jackson is coming to the Hill to speak to Rob Andrews, Democrat from New Jersey. We sure would have loved to have her at this hearing. She's also meeting with Southern Company CEO today in the D.C. area. So I think it just goes back to the debate that I think EPA is dodging the hearing and not coming. And just put that back on the table as we talk about why EPA is not here. Does anyone believe that shutting down taps is a good idea? Ms. Sullivan, yes or no?
Absolutely not, sir.
Okay. Mr. Lawrence?
No.
Ms. Adenturak?
No.
So you don't think shutting down taps would be a good idea?
There's a lot of people that require these jobs.
Okay,
right now.
great. Thank you. Mr. Glenn?
No.
Mr. Goldsmith?
No, it would be devastating for the economy.
Mr. Graffy?
No, it would be bad for the economy for
Great.
Alaska, but
Mr. Meyer?
we need to.
No.
So everyone agrees that TAPS is a very important, and if you all were here for the opening statements, I have a brief connection because my father-in-law, deceased, worked on it. So one of the great migration up there for a benefit of a better life. But TAPS is challenged, is it not, Mr. Sullivan?
Yes, sir, principally because of the lower throughput.
And what happens? What happens if you continue to have lower throughput?
Well, at lower rates of throughput, the velocity is slower, the temperature of the oil is slower, and what it does, it creates more technical problems.
Like what?
Like the possibility of leaks, but also the possibility of, as we experienced this winter, we had a shutdown that, to be honest, was quite a dicey situation. It was shut down for 5 days in the middle of a very cold Alaska winter. And
what does that mean? We don't really understand cold until you talk about
there were spots on
Alaskan cold.
There were spots on the pipeline route that were down to 35, 40 below zero.
So you need the flow to keep it warm enough so that it doesn't crack?
So it doesn't crack, so you don't have technological challenges. And when it's lower throughput, you have water that drops out, you have wax buildup. So there's a number of things the state's doing, that the private sector's doing to address those, but the number one way to address the technical challenge and environmental risks that come with lower throughput is to actually increase throughput. Which is what we're focused on.
Mr. Goldsmith, can you talk about, from being from the University of Alaska, the economic impact of shutdown of taps?
It would be devastating because it would, in one swoop, knock out about a third of the total jobs for the economy. Those jobs associated with activity on the North Slope, production.
So we need more supply to keep taps operating.
Exactly.
It's critical.
And it would also devastate Alaska's revenue picture because we get about 90% of our revenues from.
Yeah, Mr. Glenn, and of course we're also challenged understanding this great area that you represent and have a title of executive vice. What's your
Vice President of Lands, Natural Resources.
So what does that mean? Well, I mean, in common terminology, when we have governors and we have councilmen and we have counties, what is that in a hired position? Is it an elected position?
We were created by Congress. We were created to resolve the issues of the claims of Aboriginal title and to avoid the mistakes perhaps of the lower 48 Native Americans. So they created these 12 land-based corporations. So we're an artifact of Congress, but we've imbued our regional corporation with the values of our people. We're owned by the Inupiaq Eskimos who live in northern Alaska.
So is it safe to say that you're being present here today is representing those tribal areas and
yes.
And that the unity of the.
I'm speaking for the residents of the North Slope, and I'm speaking as someone who's currently employed by this regional corporation, but who also has been employed and worked with our local home rule municipality, which depends on industry in its region for its tax base.
Does Citizens in Alaska still get a check based upon oil production in Alaska across the board?
They get a permanent fund distribution annually.
Every year?
Yes.
An annual check? And has that amount gone up or gone down? Anyone know?
It fluctuates, but I bet
Dr.
Yeah, last year was $1,281, and it fluctuates between 1,000 and 1,500.
And what happens if TAP shuts down?
That wouldn't go away immediately, but it would disappear pretty quickly because the permanent fund would be needed for.
And I only have 26 seconds left. I really appreciate the testimony. It's really great. Mr. Meyer, I want to ask about this Environmental Appeals Board. Did we ever authorize it in the statute?
In the Clean Air Act, no.
So we have the EPA did a permit, and so a regulatory appeals board really denied it. That's the process, right?
No.
It's really the stationary debate, and I'll end on this because my time's up. Mr. Graffy, my point would be if you have refineries, stationary source, we don't regulate and include the emissions of trucks that go in and out of the refinery, and that's the debate of your position that tugboats going to and from the stationary source should be part of that calculation, and I would reject that. I yield back my time.
The gentleman from California is recognized for 5 minutes.
Thank you, Mr. Chairman. Under the Clean Air Act, EPA's decision-making is deeply informed by the views of stakeholders. This is one of the Clean Air Act's great strengths. We need to be very careful about changes in the Act that may have the effect of reducing stakeholders' ability to weigh in on agency decisions. We often hear from industry, as well as the public, that they want EPA to consider their views, and no one wants to go to court except as a last resort. In the case of Shell's plan to drill offshore, many groups, including the Inupiat community in Alaska, had serious concerns about the impact of Shell's proposed operations on public health and the environment. They were able to petition the Environmental Appeals Board to review EPA's decision to grant shell and air permit. This bill that's before us would eliminate the right of concerned citizens as well as industry to petition the board for review. Mr. Graffey, can you describe the role of the Environmental Appeals Board plays in allowing Alaskans to participate in the permitting process?
Yes, the Environmental Appeals Board allows participation by Alaska citizens without having to file filing fees. They don't need a lawyer. They can participate by phone. It opens up, it accesses for them an ability to challenge permits if they have been participating in the administrative process.
Yeah. Well, I think that there's a lot to be said for allowing issues to be resolved administratively rather than forcing everybody to the court. The Environmental Appeals Board also has tremendous expertise because it considers all permit appeals. Mr. Myers, you described the bill's approach of requiring all appeals to go to the D.C. Circuit as, quote, centralized for consistency, end quote. Doesn't the Environmental Appeals Board already provide such centralization and consistency?
I would agree it probably centralizes. I'm not sure in terms of consistency if that is referencing other decisions. I think they've only been involved in this one decision.
In fact, under the bill, onshore drilling pre-construction permits would be reviewed by the Environmental Appeals Board, while offshore drilling pre-construction permits would be reviewed by the D.C. Circuit. The result is greater fragmentation, not centralization. I want to point out about this appeals board, it was set up administratively under President Bush, and it's consistent with the law that says the EPA can act administratively, and the administrator doesn't have to be personally involved in every decision, so she can delegate it to this board. The bill does allow permit applicants, the oil companies, to file an administrative petition for reconsideration if they oppose an EPA permit decision. Mr. Lawrence, do you think it's fair to allow only oil companies and no one else to request administrative reconsideration of a permit?
We actually welcome and comply, and more than comply with the regulatory requirements that we have. We welcome input to those decisions. The primary concern that we have is with the timing and the timeliness of those decisions.
Right. I think fairness means we provide the same procedural rights to all stakeholders rather than providing special access only to favored parties, and it sounds like you don't disagree with that point of view.
When I look at what we've done through our consultative processes, we've consulted with more than 450 at more than 450 different times across.
And I'm not talking about who you consult with. I'm talking about who EPA.
And we would certainly support comments into an EPA process.
Ms. Otungarok, I'm interested in your view about whether it makes sense to have Alaskans come to Washington, D.C. to resolve local clean air issues. How long did it take you to travel here for today's hearing?
I started flying on Sunday night, and I got here Monday afternoon about 4 o'clock.
Do you think it's appropriate to require Alaskans to come to Washington, D.C.?
It would be a great taxing effort for those that have respiratory difficulties to try to take that trip. Many of them would not be able to come down and provide testimony on their concerns.
The bill would also The bill would also exempt vessels servicing a drill ship, such as icebreakers and oil spill response vessels, from having to install pollution controls. Mr. Graffey, what percentage of the pollution would this exempt from pollution controls, and are there controls that could reasonably be applied to these vessels?
It would exempt up to 98% of the pollution from Arctic offshore drilling from those controls. And I do, although I'm not an expert in the technology of air pollution control, I believe there are controls like catalytic converters, et cetera, that could be put on those ships.
Okay, thank you. I see my time has expired. Thank you, Mr.
Chairman. Mr. Waldron, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Myers, where's the EAB located?
It's within EPA.
Physically, is it here in Washington?
Yes.
So if somebody wants to come appear before or protest something and have a hearing, where do they have to come?
Well, I've not practiced before the EAB myself.
But it's here in Washington.
It's here in Washington, D.C. There was a reference to allowing testimony by video conferencing. I couldn't attest
Which would make sense. As Chair of the Communications.
To that, if you'd like.
Briefly.
You can call in. You don't have to. You don't have to come.
Yeah.
You don't need a lawyer, and there are no filing fees. So it's an easier access system for regular citizens.
You don't need a lawyer.
No, you don't.
What a wonderful place. Mr. Sullivan, first of all, thank you for your varied service to the country and to the state of Alaska. I spent my first year in college at Fairbanks in 1973-74 and traveled around Alaska. I have relatives up there. I want to ask you, you mentioned in your testimony lack of transparency of the administration's federal lands policy, something my constituents in Eastern Oregon are very concerned about. Can you just briefly talk to this new wildlands policy that's come out and the impact you see in Alaska?
Yes, sir. That's just another good example. It's mentioned in the testimony, but it's a Department of Interior, as far as we can tell, internal guidance on possibly having federal lands take on the use of a wilderness designation without actually, A, being okayed by Congress, and even going through a regulatory process. And I'll just very quickly mention one of the things that we've been trying to do is get input as a state with the federal government. We've been asking for input. We've been asking for a heads up on all these different changes, these lists that I put. And in that particular instance, I had a meeting with a fairly senior Department of Interior official all about the state of Alaska wants input on any major decisions, notice. Oh, yeah, we're going to provide that. Within 12 hours after that meeting, they announced the wildlands policy, which, given that we're the largest holder of BLM lands, is going to affect Alaska and possibly overturn what the NPRA is focused on, which is a congressional focus on resource development, and we think they could try and change that through administrative fiat.
We're already experiencing problems in the Northwest with power line sightings that now are having to be stopped and reviewed under this new wildlands policy to see if it really have to be treated as wilderness. Mr. Lawrence, what are your global competitors' experiences with governments such as Norway, Russia, Greenland, and Canada regarding how they allow drilling in the Arctic? And how do your spill response capabilities compare to other companies in the Arctic region?
Yes, thanks very much. And that's not only our global competitors, but ourselves. We're active in those areas also. If we look at our global competitors, there's just been significant discovery made offshore Norway that was just announced last week in the Barents. There's significant activity offshore Russia in the Sakhalin area. We are part of that. There is significant activity offshore Greenland in a major lease sales, and we're also part of that. But
so what's your timing process going through their regulations and all?
The timing processes are much expedited in places as diverse as Norway and Russia.
So you're 5 years here. What are you running there?
Years versus 5 years.
How long?
Years versus 5 years.
All right. Dr. Goldsmith, I was actually on the Fairbanks campus, not the Anchorage campus. What effect would market certainty on Alaska OCS production coming to full scale have on oil prices in the short and long term? It seems to be we're back in kind of a speculation mode here, I realize, in the market. But there are projections long term of oil being $120 a barrel. We'll try and.
Yeah.
Anyway, it's a blocking maneuver here. But $120 a barrel, I mean, part of it is supply and demand, right? And that affects market price.
Yeah, I think the major impacts would be on national security, on the balance of trade. I don't think that it would have a significant effect on the price of oil because of the way the world market works. I mean, Saudi Arabia could
they could just
cut
some,
back by 1 million barrels a day.
You referenced in your testimony 35,000 jobs long term. I think it was Mr. Lawrence said 50,000 jobs. I'll take either of those numbers right now, but it is significant, right?
It is significant in the Alaska perspective, certainly. Yeah. We're a small state, and there are a large number of jobs, and they're all very high-paying jobs, so they're important jobs.
I thank all of you for your testimony. Thank you, Mr. Chairman.
Thank you. Ms. Capps, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I want to begin by, unfortunately, expressing my frustration with this process. While I appreciate that this committee has invited witnesses from Alaska to testify, the potential effects of this legislation go well beyond that state. It's important for this subcommittee, I believe, to hear from EPA as well as other states affected, particularly California, about this legislation prior to marking it up. For that reason and others, I have to say that in its current form, I cannot support this draft bill. If enacted, it would result in significant increases in air pollution in Santa Barbara County, which I represent. At this point, I would ask unanimous consent to enter a letter addressed to you from the County of Santa Barbara into the record.
Without objection.
The letter expresses concerns with provisions contained in the discussion draft that would weaken California state regulations limiting air pollution. Thank you. Mr. Graffi, I want to thank you for your testimony. I thank all the witnesses for your testimony today. I represent California's Central Coast in Congress. We're home to an active offshore oil and gas industry. Right now, as I speak, over 20 platforms are drilling in the Santa Barbara Channel just a few miles off our coast. Those facilities emit air pollutants that are known carcinogens and cause respiratory problems. The facilities are also serviced and supported by marine vessels that release large amounts of air pollution. You write in your testimony that from 75 to 96% of the total of each regulated pollutant is emitted by support vessels in the Arctic. Are there no ways for the industry to control these emissions, or are there? Mr. Graffi.
I think the technology exists that would be able to control those emissions if EPA applied them.
Is this technology readily available?
I believe it is, although I'm a lawyer and not an expert on the technology, but I believe it is.
Would you agree with me that the draft bill would bar a permitting authority from requiring a company to apply those technologies in order to reduce pollution from these vessels?
I agree.
I'm also concerned that the draft bill would bar the application of other clean air rules. For example, the California Air Resources Board has promulgated a harbor craft rule designed to help coastal areas come into attainment with ozone and particulate matter air quality standards. It appears that the proposed bill would exempt service and support vessels for OCS drilling operations from the current harbor draft requirements. Would you agree with me that the proposed bill would help companies escape regulation of the Harborcraft rule recently adopted by the California Air Resources Board?
Yes, I think it would.
Mr. Chairman, I think that speaks to the need, at least from this perspective, for an additional hearing on this draft bill so that we can get some other folks to enter into the discussion. I think we need to have views of officials from California on the record. I know that there are many that I have already expressed their concern to me about what's being designed. You list in your testimony a variety of health problems associated with the potential emissions from proposed offshore drilling. Santa Barbara County expects to realize significant air pollution reductions from service and support boats that serve the OCS drilling facilities as a result of the California Air Resources Board Harborcraft regulation. NOx 40 tons per year, particulate matter 8 tons per year, reactive organic compounds 5 tons per year. So I'm wondering if you would share with the committee some of the public health benefits that people living in my county or some similar folks that make their living in Santa Barbara Channel, like fishermen, which I'm sure is going to be the same in Alaska as well, to see as a result of these reductions.
Lower rates of asthma, lower emergency room visits, etc.
Those are pretty big cost savings. It's important for a responsible regulation to occur. Don't you agree for service and support vessels associated with OCS development?
I agree, and that's true of Santa Barbara. It's true in the Arctic even more so, perhaps.
Emissions from marine vessels represent the single largest source of smog-forming air pollution in Santa Barbara County. They account for over 40% of the air pollution emissions. I think it's important to the attainment and maintenance of the air quality health standards that all marine vessels plying anywhere, in my opinion, but at least in the areas that I represent, Santa Barbara Channel, are subject to air quality regulations. And whatever time I have left, Ms. Tungarak, I thank you so much for your testimony, for traveling to Washington. I think it's important for the committee to know the personal stories of people, a person that you know who would be impacted by this draft bill on your community, because you're the ones who will bear the results of the regulations.
We have many people that have developed respiratory distress. I have grandchildren that have asthma. One of them is living with me right now. Anything that affects the air for this child would be devastating. For us, having to send a child out of the community to receive care when we're in the villages, it takes the parent with them. It takes all the hats that they wear with them. So it takes not just the patient, but the hats that the family wears with them. It costs a lot for us to leave the village. We don't have many resources to help us while we're out there. We have minimal resources to obtain
You can go on, but just summarize quickly.
Obtain assistance for our efforts to receive health care, and it's very difficult, and it costs a lot.
Thank you.
Thank you very much.
Mr. Barton, you're recognized for 5 minutes.
Thank you. My good friend from California just talked about 20 active drilling platforms off the coast of California, I assume near her district or in her district. Mr. Sullivan, how many platforms would be drilling today if you had, in Alaska, if you had gotten the permits that you asked for?
Well, Representative Barton, I know that, and maybe Mr. Lawrence can speak to this more specifically, but I know that last summer there were at least 5 exploration wells that were going to be drilled by Shell. That would have been hundreds of jobs for Alaskans. And
5 for 4 months. Is that, Mr. Lawrence, is that a good number?
Yeah, that's correct.
I think 5 is, what, 20% of 25 or 25%? So is Mr. Sullivan, in your opinion, is there a true public health concern for the people of Alaska if 5 platforms drill 4 months a year?
Mr. Barton, I'm not a health expert, but I think that the answer in general is it would be minimal. And I also think that it's important to recognize, and maybe Mr. Glenn can speak to this, that on the North Slope, including leaders such as the mayor of the North Slope Borough, who's the senior elected official up there, there's support for this exploration drilling.
Mr. Lawrence, do you know, can you tell me if California is self-sufficient in oil production in terms of turning into, do they produce enough oil in California that's turned into gasoline to take care of all the cars and trucks that are in California?
No.
And to the extent they import oil, isn't most of the oil they import, if it's domestically, isn't it from Alaska?
Much of the oil that comes to California is coming from Alaska, and much of that is dependent on taps.
Could you, Mr. Lawrence, compare your interaction with the EPA in Alaska to your interaction around the world with other national environmental agencies?
Thank you. I've had the privilege to be able to look for oil and gas around the world in my role as leading Shell's exploration efforts. This is perhaps the most difficult region I've ever been in any country, in any location, for working through the permitting process in Alaska.
And how many billions of dollars has your company invested so far in these leases?
We've spent over $2 billion on the leases. We've spent over $1.5 billion on exploratory activities, including science programs, including seismic programs, and including what we can do to develop this safely.
And you've yet to be given the final permit to drill one well.
In the time that I've waited to drill this one well in Alaska, I've drilled more than 400 wells, exploratory wells worldwide.
Mr. Myers, you were general counsel for the minority of this committee when we passed the Clean Air Act amendments back in 1990. Isn't that correct?
No, I was not general counsel at that point in time.
You were on the committee, the Republican committee staff.
I was chief of staff to a member on the conference committee for the 1990 Clean Air Act.
So you were part of it.
I was part of the discussions, yes.
Do you have any recollection on this specific issue in those discussions?
Yes.
Was it the intent then of those that, I was a junior member, so I was not a conferee, but I was a member of the committee. I certainly don't have a recollection that the way EPA is acting today was our intent. Can you enlighten us if you have a recollection when we put these things into the law?
Well, I think my personal recollection is not obviously part of the legislative history. When I looked at the legislative history of this, it seemed to be centered primarily on the experience of California, primarily on the experience of trying to address onshore air pollution and trying to make sure that if somebody onshore, a factory had to install something that was a stationary source offshore would have to do something similar. That seems to be clearly what was intended.
And my final question, Mr. Lawrence, can you have your staff compare the emissions of your drilling platform one of your drilling platforms to the emissions of a 747 airplane?
Yes, we'd be happy to provide that comparison.
Because my guess is that a 747 is going to have more emissions flying in and out of LAX than one drilling platform operating 4 months off the coast of Alaska. That's my guess, but I could be wrong. With that, I yield back.
Thank you, Mr. Barton. Mr. Green, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Like my colleagues, I'd like to express that we give EPA as much of an advance notice for these hearings simply because they need to be at the table, and I would hope we would keep that reserved place that my colleague from Texas, Barton, mentioned that for the EPA administrator. Mr. Lawrence, first, congratulations. I have a district in Houston, and I know Shell got one of the first actually drilling permits in the Gulf of Mexico, deep water, and having a lot of Shell employees and a refinery and chemical plant in our district. I was proud of that. I'm glad the agency's actually releasing more permits, not near as much as we need. But let me talk to you about Alaska, because I've had the opportunity to be in Alaska. I was actually on a drilling rig in the Cook Inlet, Kenai Peninsula, and the North Slope, both as a state legislator and as a member of Congress back in the 90s. Let me ask about this Environmental Appeals Board. EPA has twice issued permits, and the Environmental Appeals Board has twice remanded the permits, citing inadequate analysis and support. Critics of the bill say that the language transferring the authority of the permit decisions from the EAB to federal courts would stifle local shareholder involvement. However, as far as I know, and it was made earlier, that the same location is here in Washington as though it would be the federal court. And I know that may have been under a Republican administration that the EAB was created, but there seems to be a problem. Can you elaborate on that EPA does not issue a final order and bringing an issue to judicial review extremely difficult compared to what's been happening?
I think the greatest challenge that we face is one of time. And to be clear, the drilling season in Alaska is at the most 4 months, from July 1st and it goes to at the latest October 30th. The permitting process and the reviews of that permitting process and that challenge typically can take longer than the time that that drilling window is open. And what that does is effectively every time it goes through one of these review processes, that extends beyond the time for the drilling window and causes delays for another year. It takes more than a year to plan the logistics to be able to drill a well in Alaska, to be able to do it safely. And that's what we're trying to do, is to get out in front with enough clarity, certainty, to move forward in a timely manner and to have our investments follow that path.
Okay. And I understand over 6 years and $1.5 billion, and you cite Shell's work, multiple years of 3D seismograph collection, first of its kind baseline science, shallow hazard surveys, geotechnical programs, numerous social investment initiatives, and hundreds of meetings with North Slope residents. Additionally, you've utilized unmanned aircraft and seabed listening devices and unmanned submarines, to name a few. And I know I read Mr. Graff's grievances with the process, but all those things that Shell did, is that required in Norway or Denmark, who has control of Greenland, or even Canada?
We've done one of the most intensive preparations for this program that we've done in any theater around the world.
Okay. In my time left, I want to get back to the international issue, because when we ran into the moratorium in the Gulf of Mexico, I said, why don't we just apply Norway standards? Because I've been to Norway. I know all our majors are there. In Statoil, at least the last time we had a lease in the Gulf, actually was the highest bidder for leases. And if Norway can drill in the Gulf, and we can drill off Norway, and they have, I understand, the gold standard. Norway, Russia, Greenland, and Canada are exploring the same thing. Can you talk in detail about how far they're along in developing these resources, and the successes or failures you've had?
Yeah, I'd just like to be clear. I think we have the gold standard here in the U.S. also, and I think we operate to that gold standard. And
is there any difference between our standard and what you would do in the high north in Norway?
No, we've taken most of the best practices that we've had from both places, looking at what we would do in Norway and what we would do in Alaska, and compared those. Let me just say the development of those standards. We've been operating in places like the North Sea for many years. There's things that are such as a safety case, which describes identification of the hazards, ways to mitigate and put barriers to those hazards, clear roles and accountabilities for that. We support that. We implement those in all of the operations that we have. If we look at such things as how we would handle mitigants to stakeholders in communities, we have the same kind of practices in dealing in Norway as we would here. We've looked at discharge in Norway. How does that compare to discharge in Alaska? We've tried to take the best practices from both. So Norway has standards. We have strong standards here that protect the environment, and we comply with and exceed those standards. In Russia, we similarly we're drilling wells, producing wells in Russia right now. Russia has similarly elevated their standards, and we've complied with those. The difference is the uncertainty in the timeline with which you're able to move through those. And they provide clarity so you can get to the point in Russia where you're able to drill a well. And I would just say, finally, in Greenland, we have now just applied for a permitting, but as you know, another oil company actually drilled wells off of Greenland after a much shorter time in accessing their permits.
Mr. Chairman, it's amazing that we're much slower than Russia.
That's a sad state of affairs. Mr. Gardner, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you again for your time and testimony and traveling so far to be here, to many of you. But as I've noticed on this committee throughout the short 99 days that I've been in Congress, there seems to be a lot of things that get said that don't necessarily, that aren't the truth in terms of how they affect or impact a bill. And so I think there's a lot of miscommunication and confusion that is out there, and that various testimony has presented. And so I want to clarify a little bit of this. The fact is, these ships that people talked about will be and are regulated. They are regulated under Title II of the Clean Air Act. Is that correct, Mr. Myers?
Yes, and as my written testimony points out, EPA has been very active in this area over the last 10 years.
So to say that they are completely exempted, gutted, is untrue.
Right.
And when somebody has a refinery, is the delivery truck to that refinery counted as the refinery's emissions?
BAC does not apply. Basically, the Clean Air Act contains a definition, 302Z, of a stationary source, which excludes those emissions resulting directly from an internal combustion engine for transportation purposes, or from a non-road engine, which is what a marine vessel is, or a non-road vehicle.
So the train that delivers coal to the factory, the UPS truck that delivers parts to the dealership, those aren't counted as part of that store's source?
I think the issue is, and as this legislation would still count those emissions will be counted and effectively attributed to the source for other purposes. The issue here is whether you're going to regulate a ship as a stationary source, and the Act doesn't require that. That's the interpretation. The interpretation difference between myself and Mr. Graff's interpretation of the Act is he reads Section 165 differently than I do in terms of just the statutory construction. So we have a fundamental disagreement on how PSD applies.
Thank you, Mr. Myers. And then I've also heard that this takes away people's ability to address their grievances, to comment. Can you please tell me a little bit about how the notice and comment period would work under this?
Well, it doesn't affect any other procedures. It says basically that you have 6 months from the time you have a complete permit application, and then then it becomes a final agency decision. The issue here that we've been talking about with respect to EAB is that EPA has effectively taken the position in filings in a court case that the Clean Air Act statutory limits do not apply to EAB review.
So the assertion that the bill will prevent grievances from being heard is untrue.
Yes. Basically, there will be a shortened process, but the public process provisions are not amended by the legislation, and everybody has recourse to file a judicial petition.
Thank you. Do they need a lawyer to do that?
Sorry?
Do they need a lawyer to do that?
Well, as a lawyer, I'd say it's advisable.
It's not the Lawyer per Job Creation Act.
I believe it would be possible for somebody to appear on their own behalf, but
Thank you. Thank you. And Mr. Sullivan, what certainty would the Jobs and Energy Permitting Act provide for businesses and job creators in Alaska?
Representative Gardner, I think that's the key question, because what I tried to lay out in the written testimony is that across the board, in terms of exploration and production of hydrocarbons on both state and especially federal lands, there is immense uncertainty across the board throughout the state of Alaska. That's why I provided all those different examples. And what we see, it's chilling investment. Companies don't know how to make decisions right now.
This would provide certainty.
This would provide significant certainty in that area.
Thank you. Mr. Lawrence, would the millions of acres leased in offshore Alaska, where companies like yours have not been permitted by the government to drill, be included in what President Obama refers to as idled leases when he talks about the use it or lose it issue?
It's particularly painful to me to look at the use it or lose it issue as it would apply to Alaska, since I've been trying to use it for the last 5.5 years.
You were trying to use this, and thank you, that's good enough. Before Alaska, what was the longest amount of time you have witnessed between a lease being purchased and drilling operations commencing for permitting reasons?
This is the longest that I've seen for permitting reasons.
For permitting reasons, thank you. Mr. Myers, in your testimony, you mentioned that EPA's regulations promulgating the relevant clean air section 328, should not be used for the purpose of preventing exploration and development of the OCS. However, after over 5 years, that appears to be exactly what is happening here. Would you agree?
Yes, I think it's been. I have not been involved in a lot of this, but I think that the process has been excessive.
Mr. Sullivan? Yes. Mr. Lawrence?
Yes.
Mr. Glenn? Thank you. Thank you for your time today. Yield back my time.
Thank you, Mr. Gardner. The gentleman from Kansas, Mr. Pompeo, is recognized for 5 minutes.
Thank you, Mr. Chairman. I think we've gotten to most of the things I wanted to talk about this morning, but I have just a couple things I'd like to follow up on. You may not all see this, but this is not the only place that EPA is working against American energy production. It's not just offshore. In fact, you come to Kansas, you'll see the same thing. You say the same thing with respect to folks who are trying to grow, livestock guys. EPA, in my judgment, has truly entered a realm that we have not seen in an awfully long time. And so when you see them taking rules and contorting them into places which do incredible harm to American job creation, I think what we're doing here today is just a tiny step along the task that I'm glad Chairman Whitfield and Chairman Upton are leading us down. I wanted to ask you, Mr. Lawrence, or perhaps Mr. Sullivan too. So you've been at this since 2006. There was a change in administrations then. Have you seen any significant change in the way EPA has been responsive to you as the administration changed?
I would agree that with the comment that was made earlier, that with the EPA, I don't see this as an administration issue. I think it's an issue that sits within the EPA.
So it's internal to either the culture or the
and again, people. I'm not an expert on the internal culture.
Understand. I'm becoming one.
Yeah.
If I may, I think what we try to do is lay out examples beyond the EPA with regard to resource development in Alaska, and I do think that there's been a shift with regard to resource development and the very proactively focused shutdown resource development mindset among a lot of federal agencies, not just the EPA, and that's what we try to do in our written testimony.
I appreciate that. I guess my last question, or perhaps a couple questions, Mr. Graff. Tell me a little bit about your practice and who are the funding sources for your practice.
Well, I don't have the exact funding sources, but we're a nonprofit law firm that represents, at no cost, communities, environmental groups, individuals, and so we don't charge our clients. We get money from members who are members of our organization, just regular people. We get some foundation money, and if you'd like, I can provide. It's all publicly available in our.
I'd appreciate that. Is there any government money that comes to you either directly or through grants to foundations that in turn provide that capital to you?
No, I don't think we get.
Mr. Pompeo, would you yield for just 1 minute?
Yes.
What about being awarded legal fees after a case has been filed against the EPA?
Well, against the Clean Air Act has provisions.
But does your law firm receive revenue from that?
Yes, we do receive revenue from.
Thank you, Mr.
Great. Thank you, Mr. Chairman. I appreciate that. I was heading that direction, but thanks for getting us there more quickly. I yield back the balance of my time.
I'm sorry.
No, don't be sorry. I'm thrilled.
I recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. Let me ask this of Mr. Sullivan. What has Canada's experience in Arctic drilling proven thus far? And I'm looking at the geology, climate, and are there differences? What has Canada's experience been?
Well, right now they have a very active program with regard to the oil sands, and I think that's been an area where, although there's environmental concerns there, they've been addressed in many ways, and they have very active production and investment in that part of Canada that's really creating thousands, if not tens of thousands, of jobs.
How does their regulatory framework compare to ours?
I don't know the specifics, but we could get back to you on the
that would be great. But you're under the impression it doesn't take 5-6 years to get moving on a project.
Absolutely, it doesn't.
All right. And then you listed off in your comments, and they may have been in your written statement, but I couldn't find them, the various places that you had visited and that you had concerns that the EPA might actually be inadvertently harming the environment because they were allowing all of this production and activity to be pushed into other countries where they had no regulation or did not have regulations close to the regulations that we have in the United States. Could you expand on that for me,
Sure.
please?
I think it's a point that's often overlooked because
me too.
Ostensibly, this very anti-development policy that we're seeing in Alaska is supposedly undertaken to protect the global environment. We actually think it has the opposite effect, because if you drive development and production from countries or places like Alaska that have world-class environmental standards to places overseas that don't, and as I mentioned, every one of those countries I mentioned I've been to, then you, from a global environmental perspective, you're actually degrading the global environment because production's taking place in areas where it's not nearly as stringent as it would be in Alaska.
Could you tell me what those countries were again? Because
I mentioned Brazil, Russia, Azerbaijan, Kazakhstan, Saudi Arabia.
Okay. And as a result of not using the energy, would you think that it might also be that we're also pushing some jobs in a similar vein over there that could be here that would also be regulated more here than they would be there?
Absolutely. There's no doubt about that.
And when you talk about the global environment, you're talking about climate change and air quality issues, are you not?
Talking about degradation to the global environment, yes.
And wouldn't it be true that the nations that you mentioned, with the exception of maybe Saudi Arabia, all of that air is the same air that we're breathing a few days later?
Well, not being a scientist, I think it's eventually all air that we're all breathing.
If I told you that there was a NASA study that said the air from the Gobi Desert got to the eastern shore of Virginia in 10 days, you wouldn't disagree with me on that?
I'd believe you.
And if it's going from Gobi to the eastern shore of Virginia, it's probably going from Russia and Kazakhstan to Alaska. Would you not agree with that?
Yes, sir.
Let me switch to my friend whose name I can't pronounce, Tungnark. Can you pronounce it for me again, ma'am?
Tungarok.
It may take me a while to get that down. I have some genuine curiosity. I get global warming, rains, floods, caribou crossing the rivers. I didn't get the lack of growth in the plants that the caribou would eat once they cross the rivers, and the insect production for the birds. Can you explain those to me and how that plays into this?
The early growth of the plants are very important for the calves, and if the calves aren't able to get across the rivers before they break up, they may not get to the important.
So it's more the river than the plant production.
All of it is related.
Okay, I guess my concern is that if the global warming theory has it that the rivers are flooded, it would seem to me there'd be more plant production. Now, I understand getting across the river. I got that part. Do you see where I'm going?
Yes.
Do you agree or disagree with me that there ought to be more plants if it's warmer?
We need the animals to be there.
I understand that. I got that. I followed that part of it. I just didn't follow the other. How about the insects?
With the insects, it's related to the environment, the water, the growth of the plants. All of those are associated. If we're having changes in our environment and less of those things that are occurring naturally, it affects the amount of the insects that are available for the birds to eat.
I know this sounds like a crazy question, but it's the kind of stuff I actually like. Do you know how many insect species you have in that area? I don't know mine either. I'm just curious.
Not specifically. I know there was 114 bees at one time studied in Alaska, but that's all I know for sure.
All right. I appreciate it very much. I yield back my time, Mr. Chairman.
Gentleman from Louisiana, Mr. Scalise, is recognized for a minute.
Thank you, Mr. Chairman. I appreciate you holding this hearing and bringing this legislation. Clearly, I think we've seen a pattern for over a year now with this administration, in broader sense with EPA, the inability to allow American people to go to work, creating American jobs and creating American energy. And it's been a big frustration of mine in South Louisiana, what we're experiencing. I appreciate the comments that we had on the first panel from Senator Murkowski and Senator Begich and our colleague Representative Young in the battles that are being fought in Alaska. And it's very frustrating hearing some of the same stories of in the case here, EPA 6 years trying to get a permit for one company to go to explore to create jobs for American energy. And we're seeing that in South Louisiana, where so many of our people are still trying to get back to work, drilling safely there. And over 12,000 jobs we've lost in the last 11 months, and in many cases because the administration is not allowing our people to go back to work who didn't do anything wrong, who had absolutely nothing to do with the mistakes of BP. These were companies who were drilling safely and producing energy for this country. And, it's interesting when you hear the president going to Rio and saying, we're going to drill in Brazil, and then he comes back to America and says, and we're going to reduce American reliance on foreign energy by a third. Well, if you're shutting down production in America, you're going and bragging to the people of Brazil that you're going to drill there, and then you come back here and say, and by the way, we're going to reduce our imports by a third. Those numbers don't add up. And the American people, I think, get that. When you see the skyrocketing price of gasoline, I mean, maybe their approach is if they let the gas prices get so high, then there would be a reduction in demand, but it's because our economy would be crippled. And that's not a position we can allow ourselves to be in. And so I've got a few questions for the panel here. I'll start with Mr. Sullivan. We've heard statements from the administration that, America doesn't have the resources and we need to get it from other places because we've got less than 2% of the world's reserves. Yet I hear that there are a lot of, especially with the new technology that's out there, there's a lot more reserves that we have in this country that are prohibited by the federal government from even being explored. So, Mr. Sullivan, from your experience in Alaska, what would you respond to in relation to those claims by the administration that less than 2% of the world's reserves are in America?
Well, I think, first of all, the U.S. Geological Survey in 2008 showed that the north slope of Alaska has estimates of 40 billion barrels of conventional oil, 236 trillion cubic feet of gas, and it noted that that's probably the largest area of oil in the Arctic of all the other countries. So I think, and that's just conventionals. When we're talking about heavy and viscous and shale oil, you're going into several billions more barrels. So I think one of the important things we wanted to make sure the committee was aware that Alaska remains a world-class hydrocarbon basin compared to any other place in the world that could supply America for decades.
And I appreciate that because I've heard similar numbers. I think Senator Begich said 40 to 60 billion barrels that they want to go and be able to explore for in Alaska. You know, of course, in the Outer Continental Shelf in South Louisiana, there are many areas of the shelf that are closed off from exploration that have vast amounts of reserves as well. And of course, with the new technologies, the ability to go and explore and extract, and of course the jobs that go with it. I want to ask Dr. Goldsmith, in terms of jobs lost, opportunity lost, energy security lost, by putting these delays in place, by having administrative bureaucracies shutting off our ability to go and access these 40 billion or more barrels, what does that mean in terms of jobs lost in America and energy security lost in America?
Well, I think the biggest risk is postponement so that the pipeline shuts down, and that would be that would have the most dramatic effect on jobs, both in Alaska and nationally. You'd be talking about 100,000 jobs in Alaska and probably the same amount in the rest of the U.S. for sure.
So 200,000 jobs just on the effect. If I could, Mr. Chairman, I want to submit for the record, this is a letter from the Alyeska pipeline company that operates the pipeline, and they do detail the importance of the pipeline and how the
without objection
consequences. Because I got to go less than 2 years ago. I got to go to Alaska, and we went to Prudhoe Bay. We went to Section 1002 of ANWR, which is talked about a lot, as Senator Murkowski said. You know, this is something we still ought to pursue as well. You know, and these are areas that Section 1002 of ANWR is not the visuals that a lot of people see with you know, fields and caribou running around. Section 1002 looks just like Prudhoe Bay, and yet it's closed off from production and vast amount of reserves there. And we went to the pipeline where, you know, the threats from some of the same radicals who shut down exploration in Alaska for oil were saying, don't build the pipeline, you'll eliminate the caribou population. And we saw caribou everywhere around the pipeline, and they've said, I think its population's tripled, because the caribou actually thrive in the environment because of the warmth of the pipeline. You know, you don't hear them revising those false statements, and you know, and yet they come out and just try to shut off more things. So I don't know if Dr. Goldsmith, if you want to address, you know, not only what they said, but the lifespan. What happens if no new areas are opened up and the pipeline does in fact dry up? What kind of resource would our country be losing?
Everybody has a different estimate of what the ultimate resources are on the North Slope, but whoever's estimates you accept, they're huge, and without the pipeline or some alternative means of getting that resource to market, we're losing a tremendous opportunity for the nation.
Thanks. And final question, Mr. Lawrence. I know you've talked about the use it or lose it provisions. We're experiencing that too in the Gulf, where companies are not able to go and explore their leases because the federal government's not allowing them to, yet the clock keeps ticking. So it's like the referee's holding the ball and the clock's running and you're down by one. You just want the ball to take your shot, and the ref's letting the clock run out. So I guess that's what you're experiencing with the 6-year delay you've had.
Certainly in Alaska, but remember, we're also very active in the Gulf of Mexico. We had just made 5 discoveries in a row, and we'd very much like to appraise those discoveries and bring those online, and we're delayed in that. It's a very difficult challenge, requiring the best of our technologies to be able to go from a lease to finding the prospect to finding the drill site. And if you look at some of the major developments in the Gulf of Mexico that have had, it takes that lease period to be able to apply that technology appropriately to be able to develop the lease and produce the oil and gas.
Thank you for your comments. Thank you, Mr. Chairman. I yield back.
Gentleman from Texas, Mr. Olson, is recognized for 5 minutes.
I thank the chair. I thank the witnesses for coming today, for your testimony and your expertise. Home stretch. Last member of Congress asking questions. My focus is going to be on three issues here. First of all, Shell's experience up there in the Chukchi Seas, lessons learned from the Gulf of Mexico spill, and the impact on Alaska of the oil and gas industry and the economy. And first of all, my question again for you, Mr. Lawrence and Shell, I have many Shell employees in the district I represent, and according to testimony that many of you put forth today, and by the Alaska delegation, Shell Oil Company began talks with EPA in February of 2006, so over 5 years ago, the start of a process that is yet to conclude. EPA has twice issued permits, and the EAB has twice remanded the permits, citing inadequate analysis and support. My question for you, Mr. Lawrence, what specifically do you recommend that this Congress does to make EPA do its job?
I think what we're looking for is first, the EPA should provide clear, thorough, robust recommendations in a timely fashion such that we can make the requisite business decisions that we need to make to invest for oil and gas in this country. Now, very specifically, what we're recommending is three things. The first is we need clarity, simple clarity on where we will measure these emissions relative to the major source. And we would recommend, again, that that would be placed as a definition at where the fence line is, and we could say that the most logical place for that would be where the communities are. So that would be number one. The second thing that we would like to do is to say, when we look at this, clear definition of when it becomes a source. So, and that should not be very complicated. I would submit that something becomes a stationary source either when you start drilling, that would be the simplest way to do it, or you might say when you set anchors. Choose the simplest, tell us what that is, that's what we'll comply with, and that's what we'll move forward. And the third is that provide a time frame when those decisions must be taken. Because as I say, when the time frame for the process is significantly longer than when the drilling window is open, that simply precludes you from being able to make progress, and we would recommend a 6-month time frame.
Yes, sir. One sort of follow-up on that line of questioning. How does this unpredictable regulatory environment impact investment up in Alaska? I mean, particularly energy investment. And kind of put another way, based on your experience up in the Chukchi Seas, why would any domestic U.S. company go up there and invest in oil and gas?
As the company that's responsible for having invested the $2.1 billion there, I think it's a great question. Every day, every month that goes by, you have that money sitting there not being invested in other places that you could have invested that dollars. What that does is really apply increased risk to where you're going to make those investments. And as we all know, in an environment of increased fiscal risk and increased uncertainty, that tends to drive investments elsewhere.
Thank you for the answer. I'll use the microphone this time, so my voice kind of boomed there. But I'm going to have to cut this a little bit short, so I just want to talk about the impact of these regulations on the Alaskan economy. And we've had testimony here from many of you. I heard as I was walking down, up to 90% of the revenue that Alaska generates comes from the oil and gas industry. And so, I mean, again, what are the impacts of these regulations on Alaska's budget? Without it, I mean, how can you maintain the quality of life for the Alaskan people? And I'd like to ask that question, Mr. Sullivan, Mr. Glenn, and Miss, let me sure I get this right, the pronunciation. I want to apologize. Miss Antugurak? All right.
Well, I'll begin. We're very concerned about the TAPS throughput issue. We don't think that that needs to be the destiny of Alaska or the country to have continued throughput decline, and that was another reason I mentioned our governor. We have set out a goal for 1 million barrels through the TAPS in a decade, and we think it would be great if the Congress could support and make that a national priority. But if that continues, or as we had this winter, a shutdown, it would be devastating not only to the government funding, which is where we get the majority of our government funding, but also to the broader economy, as Dr. Goldsmith mentioned.
Mr. Glenn?
So the continued operation of the pipeline is the lifeblood of our state, and most immediately it is the single factor that has improved the quality of life for the people in our region. We're talking about where it's a huge technical problem just to flush a toilet or have safe running water. And so these quality of life improvements that have come to these far-flung communities has only been due to the presence of this stable oil and gas industry in our region.
I would just agree with what Mr. Sullivan and Mr. Glenn have said. Oil revenues are 90% of the total, and without them, I don't know how we would pay for education, health, other basic services throughout the state.
Thank you, sir. And finally, last but certainly not least, Mayor Antagurak.
Thank you. Shutting down the taps would definitely hurt many people, but it should not be at the cost of the health of the people that are around the areas of oil and gas development.
Thank you, ma'am. I thank the witnesses and thank the chair.
Well, I also want to thank the witnesses. We appreciate your being here. I know many of you came from very long distances, and your testimony was really important as we consider this discussion draft introduced by Mr. Gardner. And with that, this...
Chairman?
Yeah.
I'd like to submit for the record, a Rule 2 letter signed by all the minority members of the subcommittee, which requests...
Is it Rule 2 or...
Rule 11, I'm sorry.
Rule 11.
Rule 11. Rule 11 letter, signed by all the members of the minority that requested an additional subcommittee hearing with EPA representatives before the subcommittee markup on this bill.
Well, I think the letter's been given to staff, but thank you very much. We'll certainly take it into consideration. And I would say once again that we did invite EPA, and the EPA administrator was on the Hill today. But we've got the letter, and we're taking it into consideration. We'll be back in touch with you quickly. With that, the hearing is concluded, and there will be 10 days for additional materials to be entered into the record. Thank you very much.
Thank you.
All right.